We're going to go ahead and get this started. Is it working now? Okay. Yeah, can everybody grab a seat, and we're going to go ahead and get started? All right. Good morning, everybody. My name is Matt Drossos. I'm editor-in-chief of the Georgetown Journal of International Law, and I'd like to welcome you all to the 2008 Symposium today. We've got a great set of panelists, and this is the result of almost a year of hard work by a number of people in the journal and a number of people in the surrounding community. So I would just like to thank a couple people to kick things off before handing it over to my symposium coordinator to talk a little bit more about the substance of the symposium. So first, of course, I'd like to thank the panelists, 3 of which are here. 2 are coming after the break due to work conflicts, and so we'll be taking a break around 11:30 and then picking up with the discussions from the other 2 panelists. I'd also like to thank Professor Langevoort for moderating this panel today. I'd like to thank Paige Willan, my symposium coordinator, who has worked very, very hard over the last, like I said, year or so to put this together and to get a great panel of people together. Her assistant, Casey Lindsay, as well, and also the symposium committee who has helped them out this entire year. I'd like to mention them, Michael, Margaret, and Margot. I'd like to thank you guys all for your hard work. Finally, to the GJL staff who've also helped out today and over the last couple of months volunteering for this panel. And finally, to all of you for coming and hopefully to what is going to be an enjoyable panel. So without further ado, I'd like to introduce Paige Willan, who's going to introduce the symposium topic. Thank you very much.
First, I'd like to echo Matt's thanks to everyone who was involved in pulling the symposium together. And I will be taking a few minutes to explain the theory behind our symposium and the question that we have presented to our panelists. One of the benefits of student-run law reviews and journals is that it offers law students an opportunity to think deeply about and perhaps question the work of the academics, practitioners, and jurists whose pieces they publish. A symposium offers students the opportunity to go one step further, to propose a topic or a question to academics, practitioners, and jurists, and hear their responses. This symposium, unlike some that the journal has organized in the past, is organized around a question rather than a topic. That question is, does, can, or should international law provide incentives for international business to take into account public goals? I would like to set the stage for our panel by explaining the thought process from which this question arose and the students' understanding of the question that we have posed to our panelists. Students of international law at this point in history cannot avoid innumerable readings, lectures, and discussions on the consequences of globalization. Most of these pieces of scholarship agree that specific problems arise from the current organization of international affairs, but each thinker approaches the solution to these problems in different ways. As the symposium committee considered our topic this year, we encountered a number of these theories. A speaker in September reported on the success of an international labor organization program in the Cambodian garment industry. When presented with a reliable and easily obtainable source of information about whether or not a particular factory complied with ILO labor standards, international corporations who were the customers of such factories began to show a marked preference for factories with ILO certification. The ILO had successfully harnessed the power of profit to promote a public goal. But can this experience be expanded beyond Cambodia, beyond the garment industry? More importantly, how can the experience be replicated? Later in the semester, members of the Symposium Committee attended a lecture here at Georgetown by Lord Neil Kinnock that also addressed the issue of globalization. This lecture is in fact so on point that we will be publishing it along with our panelists' papers in the Symposium edition of the journal. I would like to quote from this speech. Lord Kinnock said, "If globalization goes on following its current course, it will also generate further economic and social inequity, and by doing that, foster resentment and resistance on a potentially destructive scale." He went on to propose, quote, "Instead of hoping for a spontaneous tide of sacrifice and self-regulation to wash over global capitalism, I believe that the argument has to be made for the establishment of a corresponding link between the making of wealth and the implications for workers of the conditions in which it is made, the establishment, in a phrase, of a recognized international social dimension for global business." So Lord Kinnock's answer to the question was increased global governance. But how does international law create an international social dimension, and what is to be done while international governance institutions are being reformed? With these thoughts in mind, the Symposium Committee developed our central question. It is to that question that I now turn. I would like to define what we intended through asking this question, to lend direction and clarity to today's discussion. Once again, the question is, does, can, or should international law provide incentives for international business to take into account public goals? First, we have asked this question in tripartite form because we want to think about this issue in three ways. The does question asks our practitioner and academic panelists to share with us from their experience in the practice and study of international law if international law already provides the incentives referenced in the question. If so, what are they and how well do they operate? The can question asks both practitioners and academics for commentary on policy questions. If international law does not sufficiently provide said incentives, then by what mechanism or mechanisms could it accomplish this goal? The final question, should, arises from our understanding of the variety of views on international law and its place in regulating international business. Like the arguments for and against federalism, there are arguments for and against regulating corporations on an international level rather than on a nation-state level. We invite thoughts by the panelists on this question as well. Second, while we focus on the operation of international law, we mean that term in its broadest sense. We include national law with transnational effect, soft international law, and even initiatives by international organizations, such as the United Nations Global Compact, or other public-private partnership initiatives. When we discuss incentives, we mean both positive and negative incentives. National law provides positive incentives, such as tax breaks, and negative incentives, such as fines or criminal penalties, for both corporations and private citizens to engage in public promoting behavior. We want to consider not just the deterrence of bad conduct at this symposium, but also the promotion of good international conduct. Finally, by public goals, we intend to evoke a broad array of social goals. Examples of such goals are the protection of the environment, reducing corruption, or promoting fair labor standards. This list, however, is not exclusive, and we enumerate specific examples only for the purpose of starting discussion. Each of today's panelists is an expert in a different area of law or in working with different industries. They will speak about their expertise, but all of their narrow topics speak to the broader issue. During the symposium, we invite you to consider the question that I have just defined and come up with your own questions for the panel. I hope that you will enjoy all of the presentations. I will now turn the podium over to our moderator, Donald Langevoort, who is the Thomas Aquinas Reynolds Professor of Law here at Georgetown and teaches, among other things, corporate law and securities regulation. He taught previously at Vanderbilt and has been a visiting professor at Harvard and the University of Michigan. He will help to draw the connections to our central question from each of the panelists' presentations. Thank you very much, Professor Langevoort.
Thank you, Paige. I'm going to play a fairly background role today, at least as we begin. As Paige indicated in talking about the topic, there are many, many dimensions to the question that was posed by the symposium editors. the ones Paige emphasized, and more profound questions regarding the nature of international law. What is it? How does it work when it moves beyond the hard law that we associate with treaties and formal governmental interventions to non-governmental organizations, the development of norms, the development of understanding, soft pressures, and things like that. And you're going to hear a lot about that today. We've decided to work in the direction of the specific to the general by beginning with two people whose work is in on-the-ground efforts to develop answers to the kinds of questions that Paige raised for you. So let me just introduce, there are three sitting to my left here. There are going to be two more panelists who are going to join us later, and since panelists usually like to hear their own introductions, I think I'll simply introduce these three and save the two final introductions to later. To my immediate left, and our first speaker, is John Williams, who's managing partner at Duncan and Williams.
Duncan and Allen.
Duncan and Allen. His specialty is in energy and natural resources law, and he has extensive experience working with governments in South America, Africa, Asia, on regulatory matters spanning the public-private divide that's going to be our focus of attention today. To his left is Daniel Runde, head of partnership development of the International Finance Corporation, a former investment banker. He was most recently director of the Office of Global Development Alliances at USAID, the Agency for International Development. And to his left, Larry Cata, professor of law at Penn State Dickinson School of Law, prolific writer. I must say my field is corporation and securities law. Larry has said some extraordinarily interesting things about Sarbanes-Oxley Act, the notion of internal controls, and various other things that are becoming an important part of our global as well as domestic environment. He also has extensive international experience, having taught in Argentina, Brazil, Belgium, the UK, Spain, Slovakia, and Italy. So let me turn to John and let you begin, and they're going to talk for about 20 or so minutes each to begin the presentation before we turn to our other speakers. So John, let me start with you. You're free to go up there or stay down here as you like.
Morning, everyone. Let me start by saying what a pleasure and a challenge it is to be back in the civilized halls of academia for a practitioner who spends a lot of time at various times in his profession in developing countries, working on law development in the mining industry in particular. And I must say I was thinking of an article that I had read in the Harvard magazine a couple of months ago about the art of making a presentation or writing something that appeared effortless. And I got to tell you, for a practitioner to sit down and try to assemble a lot of thoughts that have collected during the course of 20 or so years of practice and put them into a structured framework that is going to be of interest to people in academia, that is not effortless. That takes a lot of work. So, what about our question? Does, can, and should international law provide incentives to international business to consider public goals such as protecting the environment or reducing corruption? Now, I'm going to talk about the area that I'm most familiar with, which is the development of national laws for regulation of the international mining industry. And actually, when I say the international mining industry, as I'll explain in a couple of minutes, that includes not just multinational corporations, but it also includes national producers, mechanized miners, and artisanal miners. They're all part of this global fabric of the international minerals industry. And each of you sitting in the audience today is a consumer of mineral products in your gadgets, in your jewelry, in your eyewear, in your computers, in the seats that you're sitting on. So you're all users of the products produced by the international minerals industry. But there's a long chain before those products get to you. And the part of the chain that I am most involved in has to do with the decision, the framework for who gets to develop minerals in a particular jurisdiction and on what basis. Now, I'm going to try to articulate a thesis based on my experience with the mining industry and with the national laws in developing countries that regulate mining. And my thesis is that, well, I'm going to be talking about what we call international best practice in mining, which is really a soft law, an evolving soft law concept that affects the development of national laws that regulate the mining industry. But let me get back to our question. First of all, my thesis is that defining public goals in the first place, because we don't want to assume at the outset that we know what they are. Defining them necessitates a process of dialogue and consensus building that is open to all stakeholders, that's transparent, and that's unbiased as to the outcomes. Second, achieving public goals, once there is a consensus definition, requires not just certain behaviors on the part of industry, but just as important, on the part of the institutions and the officials who regulate the industrial activity within their particular national environments. And as I said a minute ago, an international industry like the mining industry depends primarily on law that is local, that is national and local. It's just like we say, all politics is local. Well, in mining, because mines are local. They are geographically situated. They don't move around. Once a mine is developed, it's developed where the minerals are. You've got to go to where the minerals are. God decided where the minerals are going to be, not us. We've got to find them if we're miners and then figure out whether they can be economically exploited, consistent with all of the public goals that we are expected to respect. So, all law is local, or a big part of it is local for mining companies because the minerals are local. And that's very important to keep in mind. Now, international soft law development that rewards or punishes industry for respecting or ignoring public goals can become a part of international best practice that in turn can and should be reflected in national laws governing mining. And international best practice, as influenced by this evolving international soft law, influences not only the behavior of industry, but also that of the public institutions and the officials that regulate mining activity. To start with, I assume that we don't have a lot of miners in the audience, so I'll give you a few points about that are important to keep in mind about the mining industry. Usually when you read about the mining industry in the press, it's because something bad has happened. There's been some kind of a mine disaster, or people are worried about mountaintops disappearing, or about deforestation, or about communities being uprooted because of mining activities. So generally when we read about mining in the press, we're reading about the bad side of the industry. As I said a moment ago, mining must go to where the minerals are. There isn't enough recyclable scrap metal of all the different minerals that are necessary in today's global economy to provide the growing demand. And so there's still a lot of emphasis on exploration and development of new resources. And I might add that with the rise of a lot of different gadgets and with the rise of various environmental standards, that has given rise to demand for new types of minerals, some rare earth minerals, for example, that were practically, well, they may have been known, but they weren't really commercialized until quite recently. Some of you may have heard about the coltan, columbite tantalum, of which there was a shortage a few years ago, a little before Christmas time, which was creating some havoc in the toy industry because coltan is used in the manufacture of certain devices that go into Game Boys, for example. And because of the shortage, the price went through the roof, and you had people smuggling a lot of coltan out of rebel-held areas of the Eastern Democratic Republic of the Congo and Rwanda and so on, and that's the type of thing that eventually gets into the news. The mining industry is actually a small industry, very small industry by global standards. It's tiny in comparison to the petroleum industry. It's a very small fraction. The total capitalization of all mining companies in the world is much, much smaller than Microsoft's total capitalization. If you were building a diversified portfolio reflecting, say, investments in the global economy, about maybe less than 0.5% of your portfolio would be invested in mining stocks. So it's actually a very small industry in comparison to some other well-known industries these days. As I said, mining has to go to where the minerals are. What that means is the mining industry or geologists, those who are involved in the exploration for minerals, are often some of the first investors and entrepreneurs in countries that are emerging from a civil war, that have become newly independent, that emerged after the collapse of the Soviet Union, or what have you. Countries that don't have much infrastructure, that don't have a very highly developed administrative capability. These countries are countries that are visited often first and foremost by people in the mining sector who are exploring for minerals. So one of the interesting things about the mining industry is that you have interaction between people kind of at the bottom of the economic scale in terms of governments and local communities with investors from capital exporting countries and people who are involved in exploration for minerals. Mining tends to lead to enclave development. It tends to take place in faraway rural areas. You don't see, hopefully, because none of us want to, right? None of us wants to have a mine in our backyard, so hopefully you don't see a lot of mining near major urban centers. Occasionally you do, but those tend to be mines that were developed at the same time that the urban center was developed. It presents major, major environmental and social challenges. It's very capital intensive. It's not particularly labor intensive in the modern context. At least mining is done by large multinational corporations that rely heavily on mechanized equipment and are mostly involved in open pit mining. They don't generate a lot of direct employment, but they do generate a fair amount of indirect employment and taxes and royalties. Mining is a cyclical business that goes through boom and bust cycles, and that can lead to some real distortions in government policy towards mining. When mining is in the boom cycle, it's generating a lot of profits, a lot of revenues, and country officials think, well, we're not getting enough out of this. Where is ours? On the other hand, when it's in the bust cycle, nobody can find investors willing to come in developing a mine in their country, and therefore they may be tempted to ease up very dramatically on their tax and environmental and other regulations affecting mining. International mining tends to generate revenues in foreign exchange, so it avoids the problems of having the profits locked into a block currency. Once a mine is developed, the mining company is very vulnerable, extremely vulnerable, to changes in local and national law because they can't just move the mine if the law changes against them. If the taxes rise dramatically, the royalties rise dramatically, labor regulations tighten up dramatically, or environmental regulations force them to make major additional investments. There are very significant issues associated with closure of mines, both in terms of protection against environmental damage and what's going to happen to the local community once all these jobs dry up and go away. And the mining industry is the focus of a very substantial debate, ongoing debate, as to whether and to what extent it really contributes to social and economic development. And lately, the mining industry's fortunes seem to be inextricably linked to the concept of sustainable development. So it's really a fascinating industry to work with. And my work with it has been primarily from the standpoint of advising developing country governments on reforming their mining laws and the related tax and investment and environmental protection laws in order for them to take advantage of the opportunity to attract investment capital into their resource sector and at the same time achieve public goals such as sustainable development. I'm going to give you a few examples of some soft international law that help define international best practice in mining. One would be the Equator Principles. And the Equator Principles are a set of, I think it's 10 or 11 principles that have been adopted by a group of banks. Actually, the IFC, Dan Runde's organization, has taken a leadership role in terms of getting banks together around the Equator Principles. And Equator Principles talk about requirements that they will expect project promoters to have complied with in order to obtain project financing from the bank that that has adopted the Equator Principles. And these will be things like they have done a thorough environmental assessment of their project, that this has included extensive consultation with the local community, that they have an environmental action plan in place, that they have independent monitoring and evaluation, and so on and so forth. So the banks that have adopted the Equator Principles will just say no to projects that are developed by companies that do not abide by these principles. And it requires reporting to the banks, and the banks will use their own consultants, for example, to check up on whether the company is complying with the principles. So that's an example of principles that are not mandatory. They're not settled in any law that anyone is obligated to require to comply with. So one of their shortcomings is that they won't necessarily affect mining project developers who don't have to go to one of those banks for project financing. And there are actors, in fact, there are new actors in the international mining scene who would fall into that category, and therefore they wouldn't be affected by the Equator Principles, except to the extent that the Equator Principles, the longer they hang around, the more banks that subscribe to them, by a process of osmosis, they get assimilated into national laws and become part of a kind of a global fabric of consistency in mining law, with obviously exceptions and variations. Another example would be the ISO 14000 series of standards. The ISO is the International Standards Organization, It is a secretariat based in Geneva, Switzerland. It is the association of all of the national standards organizations in countries around the world. It establishes standards on a whole variety of things, but the ISO 14000 series is on environmental management systems in particular. And what the ISO 14000 series tries to do is to lay out standards whereby companies, multinationals that have global operations can adopt and implement a worldwide environmental management system and take a holistic approach to considering environmental impacts in every stage of their business, in every part of the supply chain that they may be involved in. And there is a certification process in conjunction with this. And just to give you an example of how ISO 14000, in the context of a national law, has provided an incentive that influences business behavior. I was involved in developing environmental regulations for the mining industry in Madagascar. One of the issues you always have to deal with in developing countries is providing some kind of security bond, insurance, or what have you, to ensure that a project is going to be cleaned up at the end of the project. In the mine, this may involve really a long-term period before anyone could say that, okay, there's no longer any environmental threat from this mine. So one of the issues you have in environmental regulations in developing countries is what kind of performance bond to require. And unfortunately, one of the things that you run into also in developing countries is that they don't have the banking and insurance systems in place that will offer the type of performance bonds that mining companies can obtain more or less easily in this country or in Western Europe. So you've got to be very creative in coming up with alternative solutions. Well, in particular in the environmental regulations for mining in Madagascar, a provision was included that companies that were certified as having an ISO 14000 compliant environmental management system in place could dispense with the performance bond requirement, that would satisfy the performance bond requirement, because the idea was that these were companies that were going to be around for the long haul. They were very interested in preserving their global reputation as being environmentally conscientious, and they had already demonstrated that they were willing to put the resources necessary into managing the environmental impacts of their projects. Another example would be the MMSD project. MMSD stands for Mines, Minerals, and Sustainable Development. It's a project that was launched by a consortium of really the mining industry, international financial institutions, national government representatives in 2000 under the leadership of the International Institute for Environmental Development, I believe it is. Let me just make sure I don't misspeak here. International Institute for Environment and Development. And it was a project that took place over the course of 2 years, involved a lot of workshops in various countries around the world with various types of stakeholders to really focus on the issues of how to deal with the impacts on the environment, on society, on development of the mining industry. And a lot of good things came out of that, and it was really formed to deal with the deep-seated mistrust of the mining industry in a lot of political quarters and in a lot of communities and in a lot of NGOs. What came out of that was an agenda for the future and a couple of good publications. which I can mention later if anyone's interested. So that is, again, another source of norms, standards that people talk about, that are the subject of various discussions that go on an ongoing basis, and that eventually get incorporated, hopefully, to some extent, in national laws that regulate mining activity. Now I want to talk a little bit about the complexities of implementing national mining law reform. When we think about international law influencing the business decisions of industry in the global economy, we probably tend to think about large multinational corporations. In the mining industry, you've got a certain amount of diversity that you have to contend with once you get to the national law level. You've got your multinational major companies. Those are the ones that usually come to mind, that usually hit the front pages. Now you've got what I'll call some new international majors. These are companies with a lot of capital behind them, coming out of countries that are not the traditional capital exporting countries for the mining industry. Let me explain what I mean by that. Traditional capital exporting companies in mining would be the United States, Canada, the United Kingdom, Australia, South Africa. Now you have some new well-capitalized companies coming out of China, Russia, and India that can compete with the traditional multinational majors for resources and for sales in the global economy. Then you've got what I'll call the international juniors. Now, the junior mining companies are companies that are involved in primarily in the exploration stage of the minerals industry and not much in the actual mining stage. These companies are a fairly recent phenomenon. This subsector of the mining sector really started to come into its own in the late 1980s when a lot of the big multinational mining companies started closing down or spinning off their exploration departments. And so you had a lot of geologists and managers of minerals exploration who were out of work, and some of them went off and founded their own companies. These companies tend to raise capital on, for example, the Toronto Stock Exchange or the alternative investments market in London or comparable markets in Australia and South Africa. They're companies who specialize in finding minerals and exploring for them, which means locating a deposit, what's there, what's the volume, what's the grade, and so on, and then kind of packaging it and selling it off, or selling the company off to a more major company that can actually develop the mine. One of the important things, therefore, that has to be recognized, so this has a couple of consequences for national mining regulatory frameworks based on international best practice. First of all, these international juniors are typically not highly capitalized. They have limited resources, but they also have limited environmental impacts. But they do nevertheless have environmental impacts. And they will be the first ones who are interacting with the local community and the local environment where a mine may ultimately be developed. Another thing that has to be kept in mind is that most of them will be involved in exploration projects that will come to an end and will not result in the development of a mine. Very few of them actually will succeed in locating a commercial deposit that can be developed into a mine. So one has to think in terms of international best practice for these companies in terms of they're going to be the first ones in. They're not the highly capitalized multinational corporations, but whatever impacts their work has on the local environment and on the local community are going to create a legacy that another company is going to have to take responsibility for. And they represent a unique challenge for regulators. But even within that industry, they have their own industry groups, and they have also, through a process of stakeholder consultation and getting together in large meetings, developed a set of standards. For example, the Prospectors and Developers Association of Canada sponsors something called E3, Environmental Excellence in Exploration, which is a set of norms and standards to be followed, really by all companies involved in minerals exploration, but in particular by these juniors who are not particularly highly capitalized. Then you've got, in addition to your international juniors, you may have some regional and national juniors, which would also be companies that aren't so internationally active, but that are active in a particular national jurisdiction, which also are involved primarily at the exploration end of the industry, not in the production end. And then you've got your artisanal miners. And these would be chaotic or very loosely organized individuals or groups of individuals, some with backing from some wealthy individuals who might be located in the capital city, some totally freelancers who are out basically digging where someone found some minerals of interest that can be exploited and that don't require a lot of processing. Here we're talking about things like gold, diamonds, precious stones, and that type of thing. So all of these different actors have different motivations, different capabilities, different impacts. And then you've got diversity on the side of the regulators. You've got your international norms and standards. You've got your national laws. You've got your provincial laws. You've got your municipal regulations. And then you've probably got your local customs that have to be dealt with because, again, the mining industry is at the same time very international in terms of the distribution of its products, but very local in terms of where its mines are and the kind of interaction it has. One third area in which there's a lot of diversity that has to be taken into account in terms of taking these international best practice norms and fashioning them into a workable set of national regulatory standards is you've got national and local political goals versus your international perceptions of public goals. In other words, when you go into a national environment at a Georgetown Law Center and you're thinking of the importance of all these public goals, such as consultation with the local communities and environmental protection and sustainable development and so on, then you get into a host country to work on the reform of a particular national law. You may find that the public goals, as articulated by the people in the administration or the government there, may be quite different from what you thought the public goals were, because, after all, they have politicians too. And politicians tend to be interested in issues of power often, as opposed to issues of necessarily what is the public good. And that can be a bad thing, or it can be a good thing. Also, when you're dealing with national law reform, there is an inherent tendency to just tinker around the edges of the existing law and only look at what your neighbors are doing and how you're going to be more competitive vis-a-vis your neighbors, where rather than addressing the problems on their own terms. Some have said that this was a problem with the Redskins' offense this past season as well. So to wrap it up here and come to a tentative conclusion, I'm going to suggest that in the mining sector anyway, soft law on best international practice helps define a template for those aspects of law that need to be incorporated into national laws, but that national governments, particularly in developing countries, are often incapable of developing without outside assistance. The trick is to translate and adapt them adequately to the diverse actors, regulators, and environments so that you have a framework that is consistent for all of the different actors and all the different regulators that are involved. So, with that in mind, some flexibility is necessary in order to adapt international best practice to the needs of different national and local environments. But on the other hand, a great deal of detail and very precise delegation of authority to non-political regulators is necessary in national laws and regulations in order to achieve effective and consistent implementation of those international best practice standards. And that wraps up my presentation for now. Thank you very much.
Okay. Dan, you need to sit.
I'm going to sit.
Okay.
So I wanted to first thank the organizers for inviting a non-lawyer. As you'll see in my biography, I'm not a lawyer, nor have I played one on television. I have played an investment banker on television, so I can attest to that. I want to do a little bit of shameless self-promotion. There's a brochure about the work that we do at IFC out at back, and so please pick one up. I'm going to answer briefly the question. I want to talk about why I think the answer is what it is currently. I'm going to talk a little bit about what is this partnership stuff that I work in. I'm going to give a couple brief examples, and then I'm going to talk about some of the issues that I've seen for lawyers from sort of a practical standpoint, and I'll try and do all that in 20 minutes, so hold me to it. So the question is, does or should international law provide incentives for international business to take into account public goals? I guess my take on this would be not yet, if what we mean by that is some sort of a global regulatory framework that is telling us what to do. Obviously, I'm a non-lawyer, but my experience tells me that it's similar to the examples that John was giving of voluntary arrangements where people are forced into each other's arms for a number of reasons. The Equator Principles, which he was kind to mention, is something IFC helped pull together with, I believe it was ABN AMRO several years ago, and we had unique convening authority to do that because we have privileged relationships with financial institutions around the world, and I'll explain who IFC is, and I'll explain who AID is in the course of the conversation. But I would say that most industries that I've dealt with, whether it's the cocoa industry or the wood industry or the coffee industry or the labor standards around textiles, or an example of mining, that would strongly prefer some sort of voluntary arrangement. I'd also refer to this issue of these non-traditional players of China, Russia, and India that John talked about. I think that my experience is that a lot of companies or industries get together in these arrangements after, I think the technical term is some sort of a public relations catastrophe or boo-boo or something bad, so I'm looking for the right technical term for this, but something really bad has happened. And I think that as Chinese companies, so for instance, there was an example, I think, of a Chinese oil company that had 6 of its employees kidnapped in Nigeria about 6 months ago. It's not as if the Chinese are going to send gunboats to Nigeria and say, give me back my employees, that ultimately those sorts of blunt tools of gunboat diplomacy aren't going to work in this world of today. And so ultimately, as students of experience, I believe that in addition to the fact that as these rules of the game become institutionalized or sort of accepted practice, they're also going to have bad experiences. And I've been in some meetings with oil companies where there was a representative from a Russian oil company sort of scratching his head and ruefully saying, who are these NGOs and who do they think they are? And Well, this is an established reality for these players. They're not going to be able to avoid this, and so I think that that's sort of my answer in my mind is it does it currently? I'd say not yet. Should it? I think that we can perfect some of these voluntary approaches, but I think in the medium term we're going to continue to see reliance upon ad hoc and voluntary partnership and alliance approaches. I don't see some sort of a global law enshrined to sort of make this happen. It's going to be as a result of incentives and disincentives to do this work, and I'll give some examples as well. Okay, so why are people coming about? Let me just read something from the latest World Economic Forum just happened last week. The press release says as follows. The World Economic Forum's annual meeting closed today by a call for business, government, and civil society leaders for a new brand of collaborative and innovative leadership to address the challenges of globalization, particularly the pressing problems of conflict, terrorism, climate change, water conservation. I think you could also add some of these sort of collective good problems in industries that John raised in the case of mining. Tony Blair says globalization is forcing changes in how people collaborate in a fundamental way. You need stronger and stronger collaborative political leadership. If we are interconnected and the world is interconnected, the only way for the world to work is to have a set of common values. We have no option but to work together. What I'm seeing is, from a development agency standpoint, whether from AID or from IFC, are various industries or non-corporate actors, including philanthropy, concluding that no one can sort of solve the collective problems alone, and so there are a variety of modalities by which we're engaging in solving these problems, the changed world reflects the following things. For example, in the 1970s, about 70% of resources from the United States to the developing world was some form of foreign aid, and 30% was FDI, remittances, private philanthropy, etc. Today, in the United States, about 15% of resources from the U.S. to developing countries is some form of foreign aid, and 85% is foreign direct investment, whether it's investing in a mine or whether it's somebody at Fidelity investing in the Bovespa stock market in Brazil. It's the Gates Foundation that's spending $3 billion a year, which is the size of Switzerland or a mid-sized European government foreign aid budget. It's remittances. It's the massive flow of remittances. And so there's been this change in the flows of resources from the United States to the developing world. And I think that's the case across the global north. If you look at country after country, that's the case. If you look at Spain, that's the case. If you look at the UK, that's the case. Or if you look at France, that's the case. Japan as well. Second, I just read about this quote from the WEF. I just came from a meeting about 3 weeks ago in Switzerland that was organized by the Swiss government about how could bilateral development aid agencies work with companies and philanthropy in a more strategic way. If we had tried to have that meeting, we had 100 or so folks, mainly Europeans. If we had tried to have that meeting 6 or 7 years ago, we'd have had it in a phone booth. You'd have had 4 people. There were probably 2 or 3. There were probably at the time, there's a study by the Global Public Policy Institute. If you're interested in the study, you can send me an email, I think, or you can on the back of the brochure, so it's an excuse for you to pick up the brochure, that on the GPPI study of benchmarking partnership programs across both UN agencies and bilateral aid agencies. There were something like 2 or 3, depending on how you counted this, 8 years ago. In the year 2000 today, there's something like 30 various agencies. So I had coffee yesterday with a friend of mine who runs the State Department's program. The President's Emergency AIDS Program has a full-time person and team that just deals with corporate partnerships. I ran this program at AID called the Global Development Alliance that's been in business for about 6 or 7 years now. And the job that I currently have didn't exist at IFC in its current form 3 or 4 years ago. So variety of changes have happened. what's this partnership thing that I'm talking about? We call them partnerships. We call them alliances. It's sort of like, I'm not a lawyer, but I guess there was a Supreme Court justice that talked about a certain topic and said he knew it when he saw it, or something like that. But let me read what we have in our document that you can get on USAID's website, usaid.gov/GDA. There's a report that we did about a year and a half ago that's really excellent if you want to get into the plumbing of this. So a public-private alliance is a formal agreement between two or more parties to define and address a development problem. This is how we defined it at AID. Alliance partners combine resources and share risks in pursuit of common objectives, while recognizing that each partner will have other objectives not shared by other members of the alliance. There's no predefined maximum number of partners, and each alliance is different. It's a okay working definition for we could get into sort of theological discussions about this or that, but you'll see people talk about public-private partnerships. You'll hear people talk about alliances. You'll hear talk about partnerships. My current employer likes to talk about partnerships. My former employer liked to talk about public-private alliances or public-private partnerships. But the point is that because of these forces, because there's been this conclusion that we can't do this alone, we're being forced into each other's arms, and some of it's about exporting or agreeing on common sets of standards and behaviors. Some of it's about leveraging unique synergies that each partner has. Let me just talk briefly about what is AID and what is IFC, just so we have a common working definition. I spent 2 years at the Kennedy School, and no one really explained to me what the heck was AID when I was there. I think post 9/11, a lot of people know a lot more about AID than before 9/11. AID is the bilateral foreign aid arm of the U.S. government. There are other actors as well that do this work. There's been a tripling of foreign aid in the last 6 years. It's the largest percentage increase of foreign aid since the Marshall Plan. Sort of a little known fact, but true. Some of that certainly is Iraq and Afghanistan. A lot of that's the AIDS work that's been going on in Africa. There's been a massive increase in U.S. foreign assistance, along with other European governments. There's been a massive increase. Many countries, I'd say Japan has sort of held flat, but many European governments in particular have increased it, along with the United States. AID has programs in about 85 countries and does sort of soup to nuts work, does disaster work. They had the lead on the South Asian tsunami, so that they also do quite a lot of work on HIV/AIDS and economic growth work, soup to nuts, democracy and governance work, et cetera. So as a result of looking at these changed environment that I talked about earlier, AID, some very smart foreign service officers 6 or 7 years ago said we need to change the way we're operating in this new environment. We'd worked with companies and philanthropy in the past, but there seemed to be an increased interest on doing this sort of work. Then Secretary of State Colin Powell, then at the time AID Administrator Andrew Natsios, a graduate of Georgetown undergrad, basically understood the importance of this and gave it the political cover to kind of get this going. There was a lot of skepticism from European donors saying this was the United States was sort of shirking their official development foreign aid responsibilities by trying to privatize development. As you can see from the numbers in terms of the increase in foreign assistance and other things, that's not the case, but that we could get synergies by working more closely together. So let me give you two quick examples from my time at AID, and I'll give 2 quick examples from my time at IFC. And before I talk about those examples, I'll explain what IFC is. So Chevron is the largest investor in Angola. At the end of the civil war in Angola in 2002, they were approached by the president of the country, and they said, you really need to give back in a significant way to Angola. Chevron was not really in the development business, but knew a request that they couldn't say no to when they saw it. They went around town. They went to a number of donors, some multilateral donors, some bilateral donors, and a number of folks said, Angola's not our favorite African country. Some folks said we don't play with companies. We write big checks to governments. We don't do that. They came to AID. AID said, yes, we'll work with you. And what they did was they came to an agreement. I did the MOU work, and I'm going to come to that from some of the lessons learned from a lawyer standpoint. We went through something like 18 drafts of the MOU, and the MOU included things like, what are the regions in Angola we're going to work in? What are the sectors? Can we agree on? Can we agree that agriculture is really economic growth? Because that was something that they were interested in SME development and economic growth, and we were interested in agriculture, and could we come to some sort of an agreement that on wordsmithing that actually was a form of SME development, that working with smallholder farmers counted, and they said yes, they could, and then it was a 5-year agreement. As you'll find, I think a lot of these sort of MOUs and these voluntary approaches aren't legally binding, but they're quite socially binding and reputationally binding. And I think that's one of the issues that you're going to find is that a lot of what's going on out there is about reputation risk, and it's about, there's a concept, and certainly in the mining industry, about social license to operate. Many of you have heard that. I think that is a real issue, and I think that's one of the things that pushes folks to the table. You're not creating shareholder value if you get kicked out of the country. You're not creating shareholder value if people take over your operations. It's not fun to go to to have your kids say, why do you work in this terrible industry, or to have to explain something like that. People don't want to come from nice graduate programs and work for kind of questionable organizations. These are issues that companies have to deal with. So Chevron and AID, going back to this issue of the MOU, said, okay, Chevron was going to put up $10 million. AID was going to put up $10 million over 5 years. I won't get into the details, but it changed the way that Chevron thought about doing development work. One of the areas that they got very deep into as a result of their working with AID was this issue of agriculture. There was after 4 or 5 years, a number of powerful things happened on both sides. In terms of thinking about how to arrange strategic planning, how each organization did their strategic planning around corporate philanthropy, but also there's been a second round of about 15 million, of 7 million and 7 million focused on governance issues and agricultural financing, as opposed to sort of jump-starting agriculture. So that's Chevron and AID. I want to talk about another example of a multi-stakeholder partnership. It's in West Africa around water. The Hilton Foundation is a medium-sized philanthropy of the Hilton family focused on water. They've made that their strategic focus. They came to AID. They came to World Vision, which is a well-known NGO. And between World Vision, the Hilton Foundation, and AID, a coalition of about 13 organizations, including Cornell University, including an organization that brings together the Association of companies that make PVC piping, came together and said, we're going to over the next 5 years in 2002, we're going to do a 5-year effort collectively, bringing PVC piping, bringing community training, bringing our networks, bringing our money. We're going to reach 500,000 people and help them reach the goal of drinkable water in 3 West African countries. The issue is how do you govern? The issue of governance is something. How do you do these multi-sectoral partnerships? Whether it's if the principle is whoever puts the money gets the votes, that probably doesn't work. But at the same time, who convenes? Who hires and fires the executive director? How do you allocate resources? These sorts of things need to be in an MOU, and you need to think about these issues of governance. This is not a trivial issue. It's not esoteric. This is a real issue in terms of as you're forced to work together. So the arrangements have been an evolving one, and having trust across various partners, and it's a long-term process is another issue that you have to deal with. So one is one issue, from Chevron is the issue of MOUs. What's in it? The example from Huawei, the lesson is how do you deal with this issue of governance? How do you arrange these issues? Okay. What's IFC? I said I would give you 2 examples from AID, and I also said I'd give you 2 examples from IFC. So IFC is the private sector arm of the World Bank. The World Bank is divided into two parts. Primarily, there's the part that deals primarily with governments. That's the World Bank, as many of you know it. We work with middle-income countries through a mechanism we call IBRD, and we work with lower-income countries that we work through a mechanism called IDA. I won't get into the details here. IFC has two lines of business. We actually make money, and our goal is to encourage the development of the private sector in emerging markets, and in essence to provide a demonstration effect for other actors to get involved in countries and sectors that they might not have originally thought of. So we have an investment arm. We take equity investments, which is different than a lot of bilateral aid agencies. We lend money directly to project finance projects, so mining projects. This example of the Equator Principles, because we have these, we have relationships with banks and other financial institutions around the world. We were able to help convene that and to help set that standard. We also lend money through banks. We provide guarantees and loans through banks. We also have another side of the business, which is in essence a consultancy arm, which is technical assistance advice around 5 areas that are in essence economic growth areas of technical assistance, working with governments, working with companies, working with NGOs. So 2 examples. We have unique content on how to run an SME in an emerging market, and we have it in Belarusian, we have it in Bahasa Indonesian, we have it in a variety of other languages, and it's very practical. It's very content and it's context appropriate SME material, as opposed to saying, as opposed to using a Harvard Business School case on Cisco, which isn't probably appropriate if you have a 50-person employee company in Indonesia. That's probably not appropriate. So IBM has unique abilities to deliver content via the web and to develop technology-appropriate solutions for making this accessible. That's not something we're as strong at. So we have a complicated MOU that has to do with protecting our intellectual property. At the same time, we're trying to diffuse it. We see it as a public good, but at the same time, making sure that we get credit for the fact that this is our intellectual property and people know it's IFC. And so it's not no cash is changing hands, but what we're in essence doing is leveraging their technology and their people. They're going to be rolling out a volunteer program for employees of IBM who want to work in developing countries to help roll out this program, this unique content at country levels. The SME Toolkit website in Belarus, for example, is the most visited website in Belarus. Now, who would have thought that? But that's the case. So it's about the issue of intellectual property, the issue of who gets credit. That there are going to be times where it's not about money. It's about some sort of an agreement of leveraging non-cash. Okay, final example. Gates and IFC. How am I doing on time?
You're doing fine.
Okay. Gates, the Bill and Melinda Gates Foundation. We've all heard the Bill and Melinda Gates Foundation. After the Warren Buffett gift, they're now spending $3 billion a year, as I mentioned earlier. This is a massive. They have to keep their tax status. They have to spend $3 billion a year. It's a staggering sum of money. 2/3 of that money is dedicated to international programs. 1/3 of that money is for U.S. domestic programs. We're going to have over at IFC on Thursday the agriculture, one of the folks focused on agriculture to talk with us about what we ought to be doing together on agriculture. We have a unique relationship with Gates on healthcare, and I'm going to talk a little bit about that. We had our first meeting with Gates Foundation in 2005. It took quite a while to pull together the relationship. But what we're doing is both Gates and IFC are interested in, everyone in the development business talks about capacity building. Well, it turns out that many of the service delivery actors in Africa that deliver health care are either nonprofits or actual for-profit actors delivering health care. That's not the stereotype or the image that I have, certainly in my mind. I think about state-run clinics or maybe some small nonprofit organization. But there are a number of actors that are making money, for instance, pharmacy companies or generic healthcare, generic makers of generics, eye care clinics. These are all, in essence, run as for-profit businesses. So if we're interested in healthcare in Africa and we're interested in capacity building, then probably it's a legitimate part of the conversation to say, what should we be doing with private sector for-profit actors delivering healthcare services in Africa? This is a little bit of a mental leap for the development community, because we generally think about we need to be working primarily with governments and we need to be working with nonprofits. We're a multilateral, so we're fairly cautious, and we're owned by many governments. So this is pretty forward-leaning. What this is we've said, well, let's first do a study, because both Gates and IFC suspected that this was the case, that the number was big, that there were a number of these for-profit actors doing healthcare work in Africa. So what do large organizations do when they want to prove something they already know? They hire a very well-known consulting firm to tell them what we suspected, but we didn't know for sure, but also to get the imprimatur of an important consulting firm. So we hired McKinsey. We co-funded a study by McKinsey looking at the role of the private sector in Africa, and it's quite an interesting study. It's on our website, and we couldn't have, if IFC and the Gates Foundation had stood at a podium and said, this is important, this is interesting, we suspect this is the case, no one would have believed us. But because we had a study that we had paid for to look at this, and we had the imprimatur of McKinsey to say that this was important, we were able to do a number of things. We were able to document it. We were able to have a third party say our suspicions were correct, and we were also able to use that in essence to start a conversation about a roadshow. Because what Gates is saying is, we don't want to just spend money in the form of grants, and you, IFC, are really good at putting together private equity funds. Let's create a pooled private equity fund to invest in healthcare companies in Africa. You have offices in 30 countries. You have this ability to source deals. You know how to hire private equity managers in emerging markets. So IFC is putting up some of its own money. The African Development Bank is putting up some of its own money, and Gates is putting up some of its own money for what's going to be probably a starting point, a $500 million private equity fund. We're going to raise money from other folks. But this has taken a long time. This is a 2.5-year conversation. This has been first getting to know each other, saying we've got these suspicions that we need to develop the capacity of private sector actors. What are you good at, Gates? What are we good at, IFC? What are we missing? Who do we need to call in to help us? So we're also, the African Development Bank has unique credibility in the region of Africa. So it's a very interesting, evolving conversation. Each of Chevron, WAWI, this West African Water Initiative, the example of IBM, and the example of Gates, these have been evolving relationships. They've taken time. This hasn't happened in one step. The original signatories of the Equator Principles has grown over time. It's about trust. It's about as events happen, you need to have the flexibility to be able to adapt to those changes. So let me just go now to some of the issues I want to mention for lawyers from a practical standpoint based on my experience. So one is MOUs. I've talked about that. Second, the issue of governance and how do you deal with that? This is not a trivial issue. I would posit, though, that saying that whoever's got the money's got the votes isn't in some instances an appropriate way to do it, and so it can be tricky. Then I would say also this issue of social commitment is real, that that people don't have to partner with IFC, they don't have to partner with AID. There's this multiplicity of actors that I talked about earlier. There are these 30 bilateral, whether it's the UN system or it's other bilaterals, the various Europeans or Canadians. So if you don't keep your promises, people hear about that. And so there's a reputation risk on the bilateral side or the multilateral side. There's also this issue of social license to operate is real and growing and is a force of changing behavior. I would say, though, the other thing for if you're going to be in-house general counsels is this issue of conflict of interest and due diligence before you enter into partnerships. It's not the same thing as doing the due diligence you would do if you're making a private equity investment. But at the same time, the kinds of things you're concerned about if you're a bilateral donor or you're a multilateral donor are things like, is this organization or are these people going to embarrass us later? Are they going to make us look bad? And to some extent, there are going to be some unknowables. And you can't, and a lot of the data and there's some partners that, in my experience, where we've worked with them in some countries, and in some countries, given the country context or the situation of the particular partner, we can't work with them in other countries because of just either it's too radioactive or it's too complicated or what have you. So due diligence is an ongoing process, but it's the question you want to ask, the meta question you're trying to answer is are these folks going to embarrass us? At the same time, you just can't spend forever doing some of this work, and so there's some element of risk involved, and so you want to be able at least have had somebody document some very brief steps that have been taken to stay safe. Let me stop there, but I'm happy to answer questions. Thank you.
Back to the podium here.
Yeah, I'm sorry, I got to stand up or I will. And this may be a good moment for you guys to stand up. I realize this is a long and intense. Stand up. Take a minute. Because if you guys are like me, your blood is just.
Do the same thing.
Yeah, just stretch.
Hi.
And then once you stretch, I'll lull you back to sleep, and we'll be okay. All right, you've done enough stretching. Sit down. All right. The topic of my paper, and in fact the title I give it is From Moral Obligation to International Law, Disclosure Systems, Markets, and the Regulation of Multinational Corporations. I'm going to approach the subject of today's meeting from a little different perspective. And we all have heard the question and two very interesting and very related perspectives on the answer. Of course, the question is, should international law provide incentives, either positive or negative, for international business to consider, quote-unquote, public goals? My objective today, if I can do it, and this is a project very much at its beginning, so to the extent it's incoherent and you all see it, I hope you will raise questions and issues during the question and answer. I can only profit from, your suggestions. My objective is going to be to suggest to you that international law, as law, can actually serve as a vehicle for the enhancement of a market environment in which corporate stakeholders, not shareholders, corporate stakeholders, and principally consumers and investors can incorporate information about corporate social behavior in their consumption and investment decisions, and by doing that, change corporate behaviors. There's going to be a combo here, law, private choice. That's sort of my suggestion, and that indeed there is a space for law in that matrix. I'm going to start, and that's my objective, that in fact we can do that, and I'm going to propose, in fact, that the place for law within this context of inducing particular forms of corporate social behavior, quote unquote, whatever it may be, would be as the place the nexus, the regulatory nexus for disclosure of information, which is then used in ways beyond the authority of this regulatory force. I'm going to start by giving you a problem. I'm going to set this up in the form of a problem, and the example I'm going to use is going to touch on the responsibility of corporate actors for the working conditions of indirect employees, which is, of course, the flavor of the month. It's been studied almost to death, not quite. But that's going to be the problem. Everything from the Vatican since the 80s, I guess, to groups which are about as opposite as you can get from the Vatican have been looking at this issue one way or another. The working condition of indirect employees, I'm going to point out the limitations of law with respect to that issue, both old law and new law. I'm going to talk about the overlapping dimensions of the problem. And just to clue you in, the overlapping dimensions include disjunctions between moral obligation notions across borders. You all know this, right? My moral stance as a leader of country X may be quite different from your moral stance in the leader of principality Y. The multiple sources of values informing law, even within a polity, and all you have to do is turn on the shows you where I've gone. Turn on the television today to see that indeed in contest for control, although that's sort of a vanilla version of this. And then the third, of course, is the difficulty of transposing obligations into law that effectively reaches across borders. As we've seen, if you are a company that is annoyed by American regulatory regimes, you might well move your corporate offices to Bahrain and your operations center to Indonesia. And you're done with, or you minimize the problem. So that's going to be the overlapping dimensions of the problem. So we're going to look at, we've got the question, the objective, our problem, which is the problem of indirect employees, the limitations of law, hopefully, and then the proposal, assuming I get there in the 20 minutes that I have. And the proposal, of course, as I've suggested, cat's out of the bag, is a global system of disclosure. All right, the object of this disclosure mandate wouldn't be to establish a definitive set of behaviors. That is, we avoid the substantive issues, which is always the thing, the rock on which all this stuff crashes. Right? We avoid defining behaviors, but rather to establish a framework, a mandatory framework. That's the key, which has always been the problem. A mandatory framework within which corporate stakeholders, again, consumers, investors, laborers, and others, can adjust their relationships on the basis of behavior disclosed. That's the deal. So you've got public intervention in a market environment. That's what I'm going to propose. I'm also going to suggest in the longer paper I go on and on about this, and I'm not going to bore you with it, and people who can skip those pages won't be bored with it either, assuming they get that far. There are prior efforts in international law with respect to this sort of lawmaking. I'm going to point to the kind of spectacularly failed norms on the responsibilities of transnational corporations and other business enterprises with regard to human rights, which was a multi-year effort out of Geneva, the UN's offices in Geneva, that failed on the basis of a concerted effort by the United States and the European Union for the most part. The Europeans even more so than the Americans, although they were very sly about the way they subverted that whole process. And then ultimately I'm going to look at the content, assuming I have time. If you do create a mandatory legal global basis for disclosure, what form will that disclosure take? And I'll point you in a couple of directions, and principally for my purposes today, to this multi-civil society effort, which has been reported by the Global Reporting Initiative. It's on their website. It's a very complicated system of disclosure. So that's what we're going to do. And actually, now that I've done it, I can probably sit back and we can move on to the next person. All right, so let's talk about that. You've got the gist of this thing. Let's look at the problem. And I use, this is a real-life problem, and normally we've been talking about Bill Gates, we've been talking about large corporations, everyone likes to talk about princes and rich people. I like to talk about poorer people, the Guatemalan major domo at a hotel here who runs a cheese importing business out of Guatemala, who has the same kind of problems as Bill Gates on a smaller scale. But I'm going to go to Randy Cohen. Who's a kind of well-known ethicist. He does his little thing in the New York Times Magazine every week, and he had a problem that was actually very interesting. A problem, an American entrepreneur who is looking to lower his costs. Now, putting aside all of the social issues of exporting business at this very low stage of very low level of economic development and blah, blah, blah. Let me lay out the problem. To afford to start a new business, apparently American labor is very expensive, even in Upper Manhattan or in Oklahoma. To afford to start a new business, I must use low-cost foreign manufacturers, some of whom likely maintain unsafe working conditions. It gives me a little bit of pause, but not too much, because I continue. It's difficult to be certain from here what it is. In the relevant country, which of course is India in this case, it could be China, it could be anywhere else, it could be Jordan. In the relevant country, many workers doing the tasks I'll require receive low wages, face serious health problems, including chronic colds, fever, stomach disorders, chest pains, and tuberculosis. And then he asks the obvious question, is it wrong to start my business in this way? You all laugh. Of course, you're going to say, oh, my God, this is terrible. He should rot in hell, or some equivalent for those of you who don't believe in hell. But the traditional answer was slightly different. This is a problem that probably wouldn't have existed 20 years ago, even 30 years ago. And certainly from a legal perspective, there'd be no problem at all. Indeed, that's the point of going to India. Consider this from the nature of, you've all taken, or many of you have taken contracts. Right? Consider this from the perspective of contracts or contracts law. One enterprise is seeking to buy a product from another enterprise. You focus on the product. You don't worry very much about anything else. All you want is the product. So what are you going to be focusing on? You're going to be focusing on the amount of the product ordered, the price of the goods, delivery terms, payment terms, representations and warranties about the suitability of the product, and remedies. What you aren't going to worry about is how the producer of the product is going to get that to you. You're not going to look very carefully either, especially if he's 4,000 miles away. Your obligation, your duty, what the law and morals compels you in your business is to maximize the wealth of your direct shareholders. And if that involves contracting in this way, in a world in which everyone is mutually maximizing the welfare of their stakeholders, in this case shareholders very narrowly defined, then what's the difference? And indeed, the only time you might even plausibly have qualms about this, under the old American system, for example, I'm alluding to the, for those of you who've taken corporate law, you'll remember the case. It's Graham versus Allis Chalmers. The only time you worry about this really is if it is in your face. So if, in fact, some poor person with tuberculosis who happens to be an indirect employee hacks in your direction, at that point you probably know, and maybe you ought to do something about it. But otherwise, hey, there is no positive moral, and there's certainly no legal obligation to ensure that the parties with which one enters into contractual relations treat their employees decently, unless you know, and you've got no obligation to find out. They're dressed like me. I can have all kinds of really terrible conditions, but I look nice, and I will look you in the eye and say, hey, everything is okay. And you'll say, great, give me my product. All right. But today, of course, the answer is very different. The answer is very different today. And then that's what Randy Cohen suggests in his answer. It's your moral obligation, he says. It's your moral obligation to see that those who work for you, even indirectly, those for whose labor you profit, receive decent treatment, while wages and working conditions vary internationally. So you don't have to pay them the way you'd pay your American workers. You can pay them what you pay Honduran children if you're Kathy Lee, if you can get away with it, right? While wages and working conditions vary internationally, no one's idea of decent encompasses chronic colds, fever, stomach disorders, chest pains. What are you thinking, man? You already know this. Find someone who's going to lie to you and to not tell you this stuff and contract with them, right? And so the ethical answer to the question is a little different in 2008 than it might have been 20 or 30 years ago. Instead of the old view, right, the economics of the transaction now has to be understood in the context of all of the factors of the production of the object, in this case labor and capital, and measures efficiency and wealth production from the perspective of individual stakeholders, not just necessarily individual shareholders. That this result is not compelled by public law, right, should be of little effect. It intimates, the answer today intimates and said private values maximizing choices might have to be memorialized in contract rather than law, but they've got to be memorialized somehow. This ought to bother you. And it ought to be reflected in your relationships with someone else, even if you are moving beyond the limitations of law. Right, that's the notion. Right? Not necessarily because you're going to go to hell or some reasonable equivalent, but because it is either not values maximizing, it's immoral and not good for you, and not good for you both in the sense of your eternal soul or some reasonable equivalent, but also your pocketbook or some reasonable equivalent. But why is it immoral? Right? Why is it immoral? Well, that's the problem. It's easy enough for Randy Cohen to say, it's immoral, you can't do it. Well, where are the sources? As I suggested, there are all kinds of bases. And of course, that's good news and bad news. Some of the bases, of course, are well developed within religious sources. As I've mentioned, the Vatican, and I keep mentioning the Vatican, but it is a very rich and in some quarters an extremely persuasive source for the sort of values that get transposed into behavior and behavior norms. Well developed, a corpus of work, really well reasoned, that if you ever have absolutely nothing to do, you might pursue. But so you've got a lot of these sources of morals in faith. But for those of you who have none or whose faith is somewhat more eclectic, we have also, over the course of the last quarter century or so, also developed a secular version of this, of why is this immoral, and we look to economics. Well, what kind of economics? Not Chicago school economics, but the rising and now increasingly popular values-based economics, right? That suggests a different basis for determining welfare maximization, that looks at different sets of actors and different ways of valuing or understanding the rationality of behavior. You've got everyone's favorite in the legal academy, the binary economics. There are all kinds of other far more sophisticated versions of this. So you've got both a secular and a quote-unquote non-secular version of morality. You can choose, but there's no consensus with respect to any of these. And law itself has taken a few steps to begin to privilege or at least acknowledge this position shift. We've seen in the law a movement towards, in Germany, for example, enterprise liability, although not very successfully. In England and in India, to some extent, you've got a more sophisticated version of piercing corporate veil theories. You've got extended jurisdictional theories, especially out of Europe and sometimes Latin America. You've got extended notions of fiduciary duty. They're all tentative legal steps in the direction of extended obligation. But these are tentative, and there's no consensus. But there is one thing that is sort of basic to all of these, and it's the kernel, the insight from which I draw my own proposal, and that is Cohen suggests that whatever the basis, moral, legal, private law, public law, now proceeding with this sort of relationship requires one thing. It's basic to all these systems, not hard law, soft law, monitoring. That is, implementing the purchaser's duty to participate in the development of legal and economic relationships between the product supplier and the purchaser. And for this purpose, monitoring can be done either directly by having the guy go off to India and look at the supplier himself, Walmart, Gap, Apple, do that, or by using certain middlemen. Right? Either the government unlikely in most cases, or much more likely elements of civil society. And there is a very complex and very comprehensive network of civil society elements whose job it is to monitor these kinds of activities and then take their reports to the media for whatever value that gives them. Right. So he summarizes the consequences of this approach to the problem. What you may not do, he says, is simply throw up your hands at working conditions overseas or fob off this duty on those with whom you contract. You must strive to learn whose sweat provides your equity and how it's extracted. All right. And the basis for this, of course, is monitoring. He rightly understands that for the moment, at least, the moral obligations he identifies can be effectuated only through these extra-legal means and only by, right, observation and reporting. Right? And this turn to information as a proxy for moral choice in law is being reflected, if only somewhat tepidly, in the courts as well. I nod here not to the child of Alice Chalmers in the Delaware context, the Stone versus Ritter case for those who follow this notion deriving from the famous, although misunderstood, Caremark case, that we've moved from a system of passivity, that is, where you don't have to know what's going on until someone coughs on you, to a system that, in fact, assumes the opposite. You assume the worst, or you assume that something bad is going to happen, and you set up something. Now, the Delaware case, of course, is just so minimal. It can be, I'll wake up and ask you, although that's subject to some questioning. But you've got to set up some kind of monitoring device. And the law is beginning to recognize this as well. And indeed, the obligations to monitor for bad conduct are being extended to agents of economic enterprises generally, right? Not only under state law, but also under federal securities laws in this country and in Europe as well. And simultaneously, the law is beginning to impose monitoring, reporting, and disclosure requirements more generally, not only within the economic sphere, but outside of it as well. How am I doing for time?
You're good.
I'm okay? All right.
7 or 8 minutes.
All right. So we've got monitoring everywhere. And for those of you who've had the pleasure of going to England or to parking lots everywhere, you know that the monitoring that I'm talking about is not merely this esoteric kind of, oh, here's some older guy talking at you about watching, but it really is kind of pervasive in the most prosaic kind of way. So we're looking at cultures now where we have disagreements about sources and nature of the sorts of behavior that we can all agree to maybe ought to occur, but we seem to be coming closer and closer to a consensus about the value, utility, necessity of monitoring, reporting, and disclosure in some form or another. And those monitoring regimes, right, are increasingly pervasive, not only within the economic sphere, but virtually in all sectors of political organization. Right. The key shift, then, is not to the elaboration of a particular morality, but to information. And information in this case, of course, is not merely a process, but, of course, is the agent for forcing substantive choices. Right? You use that information. If I know that my supplier is, as was a case in one of the Jordanian manufacturers, had a glucose station and shunts on his workers so that they could work 96-hour shifts. They go pop them up in the little glucose thing and keep them working. If I know this stuff happens. If I know this, right, then I ought not to contract to them, and I ought to set up a system to deal with this as well. All right, and so that's where we tend to be now. So the problem, sort of, from this problem, you get a sense of what the contours, basically, that in which modern corporate social responsibility, if you like, operates. You've got no clear consensus. You've got this inchoate sense of morals. You understand its importance and its applicability. But that's where the consensus stops. You're not sure who ought to act on it, whether it ought to be mandated, what exactly it means, whether it means the same thing everywhere else, and whether it ought to be mandated either by individual nation states or subnational communities, or by the international community. And of course, there are two huge impediments to the last: the devolution of power. It's not revolution. The opposite of devolution, the pushing up of power from the nation state to supranational entities, three major powers that make that virtually impossible: the European Union, the United States, and the People's Republic of China, all of whom, for their own reasons, very inconsistently, though, have a tremendous fear of creating autonomous substantively regulatory authority outside of the nation state. The Chinese, for reasons of post-colonial psychosis that they still got a century to work through; the Americans, because they know what is going to happen if, in fact, they do that; and the Europeans, because they're still working it through with respect to their own member states, and they certainly don't want to share that experience outside of the Union just yet. And for those reasons, so what we have is, in a sense, what we've heard described here by the prior two speakers, a regime in which all of these things are working, and you tend to work it out through soft law. That's the regime. Soft law, contract, and indeed that was sort of where we were all going. Social responsibility is voluntary. It is like Franciscan and Dominican preachers in the 13th century standing at opposite ends of the square, begging you to follow them, but no one is going to roust one of them or impose a particular set of rules. But the one thing consistent in all of this, as I've suggested, the one thing that's consistent in all of this is information. And so if we're looking at this, and if we want to create consistency, and we all seem to want to do that, working under different regimes, especially for business, is inefficient. If we want to possibly create consistency, but we want to create consistency which is sensitive to the market nature of contemporary globalization, is very, very leery of mandatory obligations issuing from government, much less a supranational organization, then perhaps the approach would have to be, or could be, and this is my suggestion, the approach would be, a successful approach can lie in exploiting the substantively soft hard law of surveillance and using that as a wedge for creating mandatory systems, mandatory indirect regulatory systems. All right. And from that, okay.
2 minutes.
2 minutes. All right. I'm going to get cut off soon. For that, I suggest that there's a way to do this at the international level. I would propose and I don't have a specific proposal, but that it is, in fact, given all of this, it's plausible to set up a mandatory system of disclosure within the international framework, and that it is plausible. It's not merely, law professors like to propose all kinds of pie in the sky. It makes us feel good. But this is actually, I'm going to argue, at least within the realm of plausibility. I don't know if I'd bet my house on it, but it's at least plausible, right, for a number of reasons. One of them is that the relationship between information and the operation of businesses is already well understood and internalized. Businesses provide information all the time. This is not a new task, but it's a task that merely requires modification and redirection of an old pattern, a well-established pattern of business practice. Businesses work on information to some extent. They're used to doing this, and they're certainly, for public companies, used to doing this in a very, very, very broad way. In addition, businesses have been creating extensive private networks of monitoring on their own. Again, I point to Walmart, I point to Gap, I point to Apple, and their supplier chain monitoring system. Walmart monitors over 6,000 suppliers worldwide on the basis of a series of extraordinarily intrusive contracts with substantive and monitoring provisions. This is something that's not, it's not a new thing for businesses. Information gathering itself is a task that has already been comfortably given to international public bodies. The UN and other public bodies constantly gather information. So this is not giving them something new, and it's not requiring businesses to do something that they are unaware of. Right? So we've got both things sort of in place, and we've already seen how international organizations have begun to try to frame a a system, right, for actually extracting information. I point for a number of pages to the way the norms, the failed norms, created a monitoring system. The norms failed because it was overly ambitious for a lot of reasons. A big part of their ambition was to actually mandate particular substantive behaviors. Pulling that out, the monitoring component of the norms might serve as a useful vehicle. You can actually write this down in something that might actually work. So you've got patterns of behavior in corporations, patterns of behavior already within international businesses, and you've already got an attempt at crafting this in black letter in the international area. I then go on. There are a number of ways you can make this compatible, and I'll end just by pointing to them, and then I'll finish up. One of them is a very limited framework for international law. The only thing that is mandated is the provision of information. That's it. Disclosure that parallels disclosure regimes that are already internalized, for example, those internalized in the financial markets, remedies provided under domestic law, that is by domestic courts, and limited to the provision of information. Businesses do not like and do not want another large hole into which money will flow from out of their pockets into those of lawyers, too bad, and others, right? Remedies limited to compelling disclosure, right, and universal jurisdiction. If you set this up so that national courts participate by actually mandating the disclosure, you limit the remedies to disclosure, you permit national systems to create whatever other remedies they want, and you limit the reporting system to some sort of monitoring, I think you can actually get a system that would work and would benefit ultimately the way in which corporations, multinational actors behave in a consistent way across the globe. I'm done. Thank you for your patience.
Thank you, Larry. As you've noticed, our panel has grown as we were speaking. As promised, I'm going to introduce formally Jacob Werksman and Naomi Cahn when we finish our coffee break. Dan, I believe you do have to leave, so we're not going to have a chance to do the question and answer that's going to come later in this program with Dan involved. And because we have 4 minutes left, let me ask you a question so you don't get out of here.
Good. Oh, I thought I was going to dodge that. But...
No, it doesn't work. Among academics, the biggest question about the proliferation of NGOs and partnerships and alliance and soft law is that you lose accountability because of the informality. And you lose transparency because the mechanisms we have for inducing transparency with respect to governments, sunshine and things like that, don't exist on the international level. As I was hearing you describe perfectly sound innovations, I have to believe there are people out there who are saying, who elected you, the person who can decide X, Y, and Z? And I suspect someone else saying, who privileged you to impose your particular vision of values, as opposed to some voices that may not be involved. Could you address that before you leave?
Yeah, in 4 minutes or less.
Yeah.
Okay. I would say that let me respond to that, and let me also make a comment on something that Larry said to respond to that. I think for multilaterals and I'll start with multilaterals and bilateral donors, and then I'll talk about NGOs. But I think that multilaterals and bilateral donors have to be open to everybody. And so if somebody comes in the door and says, we want to work in East Overshoe, Malawi, and we've said we're all about working in East Overshoe, Malawi, and we're interested in XYZ intervention, and we've said publicly we're about XYZ intervention, it's about finding the overlap of stated interest. And so we've got a strategy. The Gates Foundation has a strategy. Chevron's got a strategy. IKEA's got a strategy. And it's a lot of this partnership stuff is about finding overlaps of interest, and that where there's not overlaps of geography or intervention or third-party partners, it's not going to work. At the same time, I think that there is an interesting question of legitimacy for some NGOs to say who picked you and who elected you. And I think that's one of the tricky issues of our system. I think at the same time, I think you're seeing in a lot of sectors sort of this dueling of what I'd call kind of these dueling, the battle of the dueling standards with VHS versus beta versus DVD. My head hurts thinking about all the different labor standards. There's something called RAP. There's something called, I don't even remember the rest of them, but my head hurts just thinking about it because it's quite theological, and how many angels dance on the head of a pin about which one, and people have made their careers on stuff that's not all that different. Or the same with coffee standards. There's a number of different standards in the coffee sector on quality and labor standards. And so there are battles going on out there for whose standard wins. I mean, and some of it is there is a commercial. Let me just talk. This issue. Some of the things that Larry's talking about. I think that this issue of a limited framework, compelling disclosure, is an intriguing one because there are, as I said earlier, I think sectors are. I think there are a lot of leadership of a lot of industries are coming to, from a risk management standpoint, all the different risks I talked about in terms of just having their teenage child say, why do you work in this sector, and I don't respect you, mom or dad, for doing this, or not getting invited to the right cocktail party at the World Economic Forum because you're in sort of a dubious thing, or because you get kicked out of the country, or et cetera, all the things I enumerated, that there's a risk management paradigm that certainly multinationals in the global north, and I think increasingly in the global south, are saying we need to deal with a number of issues. So there are some initiatives talking about disclosure. I'm not, from a personal standpoint, I think you are seeing people voluntarily do this. I think Nike has disclosed all of its labor. This is sort of a new thing. Nike saying these are all the factories I sourced from, and this was a big deal in the textile sector. I think you're going to see other sectors being asked to, if they don't, I think there is the club of, if you don't do this voluntarily, there's some really bad thing is going to happen through legislation. And you see this, and I'm not going to mention the particular agricultural sector, but we all eat this product a lot, and I certainly do. And I think the club that's bringing this group together is the threat of legislation on labor standards, because this particular line of work doesn't want to be associated with child labor and other issues. So I think that there is this club of legislation, whether it's sort of at the national level or international level, and I think it's forcing people into these voluntary arrangements. Yes, this issue of legitimacy and who's in and who's out and who elected you is a tricky one. I think to the extent you're transparent and to the extent you can be as, within the bounds of what's realistic, of being open and being transparent, you can mitigate some of those challenges. But I think on a bilateral basis and sort of these one-off partnerships I've talked about, to the extent you say, look, we're all about this region of Malawi and you're about this region, as long as you can prove that this is what we've stated is what we're all about, and there's an overlap of interest, I think you're on a safe. We've not had a lot of challenge on that, to the extent that we're able to say, look, we're open to all comers. Just show us there's an overlap.
Okay, I'm not going to deprive this group of its coffee break to the full extent of that coffee break. So we will break now for about 15 minutes. The other panelists will have their say, and we'll have time for interchange after we pick back up at 11:45. So enjoy your coffee break.
It's very interesting. It's certainly been good for my job security, that's for sure. But it's
we're on time, I think.
It's really interesting what you're writing about. It's only happened in the last 5 or 6 years when we started to kind of do this in a more sophisticated way. As I hear what you're saying, I do think there are people are afraid of being told what to do legally. All industries don't want.
Well, I'm looking forward.
But I do think this issue. I do think if there was some limited disclosure, I do think that's an interesting.
And there are a number of ways
are terrified of this.
Other one who
in a sense,
to go. And then as soon as you two have gone, and we're shooting for about 20 minutes for everybody, you go right to
now
panel
the
discussion and
fight
audience.
now moves out of the legal into control of the
You'll be able to stick around?
The businesses civil society have been in that game now for 20 years.
Good.
That's something they know.
I teach
they can never protect themselves.
so I'm going to make
The only worry is
a transition from wherever we are to
you said disclosure is right. You can set it up so that it's flexible.
Yes,
Disclosure
right.
is choosing the disclosure framework.
Good to meet you.
Disclosing why you did that, and then disclosing on the basis
Get
of
something.
It's very, very simple to start with.
It's very interesting. The Cocoa guys. So, for instance, you got the Hershey folks that are about. We're all about kids. I got an orphanage, and I'm special. They have the equivalent of a conniption. And the whole idea that there's slave labor or that even with it. The Nestle people are so self-satisfied. They're all Swiss and they're so morally they're horrible. And so then they'll give you these.
Like a blog that
that's like these lines, like these Aryan people. You know what I mean? They're horrible. But they're basically so self-satisfied, and they're like, I don't want some gringo telling me what to do. We're the Swiss, we're such a and then the Mars folks who get it, and they've really tried to lead. They're comfortable in sort of the research space and saying, okay, well, if we can kind of do cocoa quality. Oh, and by the way, as part of that conversation, we can do these other things. Yes, we're willing to talk about it, but it's got to be part of a broader.
That's right. Well, yeah, they shouldn't do it alone.
They can't do it alone, but it's also they want some cover in terms of saying this is part of a broader conversation about quality.
Of course.
But it's there is a collective goods problem too, and I do think the issue of there's sort of what they're doing is they're going to bilateral agencies and saying, why don't you take on some of this public good cost? And we're saying, well, there's a development argument for doing that, and therefore we're okay with this. But at some point,
but it's not.
You got to have. It's not our own. In the medium term, we need to get out of it. And someone ought to say there's a user's fee. Okay, for every 50-cent bar of chocolate, there's a half-cent something. There's a user fee.
But basically, you move back from the norm. We've gone from the norms to the global initiative. You can move from the global initiative to a disclosure framework. And the pieces are all there.
And so in my mind, I think it's interesting because at the same, I do think that yes, the UN is. There are some, I think it's going to happen more through SEC regulation. It's going to be you want to be, you want Sarbanes-Oxley, you want to be complicit, so you're going to tell me what your suppliers are, and that's how it's going to happen.
And that'll work too.
Yeah. So it's going that way. Sorry.
I'm Alan Taylor.
Hi.
Global Health Law.
Hi.
Sorry,
I'm really happy to have your card. I was really interested in what you're doing with the privatization of health services. And I was hoping maybe next year sometime I could call you up to talk to our students.
Absolutely. I love talking to students.
Yeah, I think it's really interesting, and we really have kind of a perspective on that.
Yes.
We have a lot of JD students as well as we run master's of law.
Oh, sure.
Law, so it's an area of interest. And I also wanted to say, the whole conversation is very interesting, particularly the lack of focus on any type of international regulatory structure to address transboundaries. I was a legal advisor at WHO.
Oh, wow.
Framework Convention. Tobacco control, which is really a different model. I mean, there's a direct entity to use the long arm of international law to regulate industry. But I thought it was particularly relevant to your presentation. Because actually, during the FCC negotiations, the idea of disclosure was very difficult. I mean, we assumed starting off that we could have this tobacco industry disclosure of expenses on advertising. You could see, the contention of our ingredients, because no one, really knows what's contained in those cigarettes. But on all fronts, there was tremendous resistance by the industry and by states, which is the United States and Japan, that represent those industries that have that kind of disclosure. So I think the idea of information seen by eyes is difficult at several levels.
Well, right. I mean, and you point out. I mean, one of my, and I didn't have a chance to talk about this. One of the kind of underlying agendas is indeed that monitoring has a very, very powerful substantive component.
Right.
And the question is not only will you disclose, but what? And in the framing of the what is where it's all at. You start, and you're right, and that is the cause of the problem. But
it was one of the really tough issues, actually. Was the disclosure, and it was a place where industrialized countries were shut down.
Right. But even there, I mean, even if you just open the door.
I apologize. I wrote notes on it, but these are 2 articles about this.
Oh, thank you so much.
Let me give you this too.
Thank you. All right.
I can hear you both with the price of admission. You're also both really great speakers.
Because
frankly,
thanks.
2.5 hours was a breaking the law.
Yes.
But it was the content was great.
Well, thank you.
Good. Thank you very much.
Yeah.
Send me an email. I'm happy to speak to your students.
Thank you.
Good to meet you.
Nice to meet you.
See you around.
Even if
right.
what you do is mandate the most innocuous of disclosure.
Really appreciate it. And, I'm sorry.
Think of it in this way.
No.
I get
Thank you.
to disclose something very small, that in fact tobacco has leaves in it. You've now opened it up for the NGO community to go out and do to these reporting companies what they do to Walmart. And say, look, consumers, they won't tell us any more than this. You really want to buy tobacco from them. It becomes, it's a part of it.
I appreciate that, the consumer, democracy. Absolutely, appreciate that. But I think it's a really sad error. You're absolutely right, of course, about the transnational, code. I mean, there's no interest. There's no stomach.
You're very familiar. Okay. And where are you now?
Regulating the industry.
That's right.
But I tell you, public health, there is.
This is your group. Okay. Well, that's nice. It helped build the room.
Now, of course, public health community is I'm too excited with the idea of using
Teaching full time?
It's like, it's like the new toy.
Right. Exactly.
But there was discussion about regulating the alcohol.
Oh, yeah. Good.
And
Teaching is fun.
handguns, and using, all sorts of
Yeah,
bad
it was a good start, and I think
public health.
after the break we're gonna continue with some good stuff.
Maybe small.
Good to see you.
Nascent, maybe it'll die.
Yeah.
A movement to really use international law in this way.
Yeah, but for me, the example of what happened to the norms is really telling. If you begin to regulate anything that looks substantive, when it comes to cross-border economic enterprises, you're going to get slammed before you even step out the door.
It's a different era.
This is 2 years ago.
That was also. I mean, I heard that the story behind that. It was the rapporteur developed his own mandate, right? I mean, there was the original. I didn't realize you were talking about that one. I thought you were talking about in the 80s.
No.
In this case, the rapporteur developed his own. It's really common. Like he decided that he had the authority. I can't remember what was the story behind it.
Yeah, but they chickened out, and they,
but he actually did that. He interpreted his name. It's not exactly right.
The Gabonese guy or the Senegalese guy?
Yeah,
what's his name?
I don't remember. I heard someone from a human rights NGO discuss this a few years ago, but that he had interpreted, where did this come from? I mean, first of all, the idea of having the code of conduct of transnational corporations in this day and age, come on.
Well, it came from, what's his name? Weisbrod at Wisconsin.
Yeah, right. It came from him. He decided unilaterally that he was going to do this. But there's no stomach in the international community.
Exactly. For anything but the problem is for anything that smells of substance.
Maybe there should be.
The Americans and Chinese will kill it.
Are the issues more poignant now even than they were 30 years ago when this stuff came up?
No, because they're there.
Have a more significant impact in welfare and development?
Yes. And the minute, and that's right, and the minute you do this, the American politicians will turn around and say, aha, we're one step closer to world government, your Constitution is not worth the paper it's written on, and the United States will become a slave to these countries that we despise. I mean, that's the argument, right or wrong with your...
As scholars, you can look down and call a spade, right? Maybe things will change. You never know. Anyway, I really enjoyed your piece. Your students must love you. You're very animated.
Oh, thank you.
That was good.
Thank you.
I enjoyed that.
Yeah, actually, I came up from Mardi Gras. I'm visiting at Tulane this year. I flew up, so I'm going to fly back down in a couple hours and go and pick up the rest of the
the festivities, yeah.
You know, down there they close the schools for Mardi Gras.
Right.
So Tulane is shut until Thursday. You can't even get access to the library because of.
How is Tulane doing? Is it making its way back?
It's making its way back. It's a long process. They're holding. And the question is, can they now kind of rebuild? And that will depend on if there are no storms the next 5 years. They'll be fine.
Right.
But I think that if there's another storm,
right. I might have to start organizing people here.
Well, come walk me. I guess I'm talking.
We are going to have to come back in about 3 or 4 minutes, so if people would start heading toward your seats.
Another neat publication, more legal publication,
Yep, I think we're fine.
Great.
Okay, if I could get our panelists back up here, we can get ready to get started.
Hi. Nice to meet you. Nice to meet you. Thanks for coming. Sure, my pleasure. Sorry I was late.
Oh, no, not a problem at all. Could I just ask you to sign in?
Sure.
A lot of the
My fake.
Symposium.
Right. What was my paper? Corporate psychology.
Paragraph C are used to allow us to use your remarks that you made today. So that's it.
2-5. Mardi Gras, Super Tuesday. Whatever. It's amazing confluence of events. Both of those.
Time in front of the TV this evening.
Absolutely. Yeah.
Does California go today? Yes, they do. So they must be, that'll be the last poll.
Right.
Okay, my paper will focus on
Corporate responsibility. Whatever.
figure I'll go ahead. All right.
Okay, you try to, and then I'll try again.
Yeah. Can everybody take their seat? Is this on?
I doubt it. Try this one.
Whereas
Hey, everybody. If we can go ahead and sit down and get started again.
I should. Well, this will be. He's got class. Professor Langevoort has class as well. So. Okay.
All right. Here we go.
be really brief.
Okay, as promised, I now get to introduce two more panelists. Naomi Cahn is Associate Dean and John Theodore Fay Research Professor at George Washington University's Law School. She has had a substantial amount of contact with Georgetown, having been the Assistant Director of the Sex Discrimination Clinic here and a visiting professor a couple of times. Her two specialties are family law and trusts and estates, and I understand the reason she was late is she was teaching a trusts class from 9 to 10 this morning. So we're glad she has the ability to join us. Jacob Werksman is an adjunct professor here at Georgetown University Law Center and also program director of institutions and governance at the World Resources Institute. He's had a distinguished career at a number of organizations in work relating to his present concern, which is environmental responsibility and decision-making, as well as international intellectual property rights and international trade policy. So we welcome both of you. And Naomi, you're going to go first.
I think I'll stand up. One thing that does not appear on my official biography, which has me teaching family law and trust and estates, is in 1991 and in 1992, I co-taught perhaps the first such course offered in the United States here at GULC, here at Georgetown, and it was called International Women's Rights. So I assume you still have an International Women's Rights course that is being ably carried on, but we started it back in 1991. So I've been doing international law at the same time as I've been doing domestic rights as well. This paper is actually co-authored with Tony Gambino, who was the USAID mission director in the Congo at the time that I lived there from 2002 to 2004. And so that experience informs some of what I'll be saying today. Now, as we consider the questions that frame the conference, can, and should international law provide incentives for multinational corporations, MNCs, to consider public goals, there are a couple of sub-issues. The initial question, of course, and I think the previous panelists have answered this, is whether MNCs should have responsibility at all for public goals. And I'll defer to the others, particularly Larry, who just spoke about this. But I agree, the answer is quite clearly yes. I think it's important for MNCs to work towards more public goals for three different reasons, in addition to the moral, jurisprudential, and economic reasons that we can all find. First, particularly, this is something we lose sight of living in the U.S., or at least some of us do. Multinational corporations have a profound effect on their local communities. Second, they operate within numerous countries, and it's important, as I think John Williams started us off with, by pointing out that it's important for the countries themselves to move towards more public goals. So one of the things I'll be talking about is how international law should be forcing not just the companies, but also the countries themselves to undertake public goals. And by pressuring the corporations, we actually pressure the companies. We pressure the countries because the companies like the stability that better run countries actually bring. And third and finally, this is contrary to my upbringing as a far to the left liberal, multinational corporations very often bring peace and stability not to the country more generally, but also to the local communities in which they work, and they can provide a lot of promise. So it's important to focus not just on excesses of MNCs, but also on the promises of MNCs. So then we get to this second sub-issue of, given that we all think this is is good. How should this be done? And here the relationship of multinational corporations to the national contexts in which they operate is important and is the primary topic of what I'll spend the rest of my time talking about. I want to focus specifically on the country governance context, which is critical on deciding on appropriate strategies to improve corporate responsibilities. And I think this is important generally, but also particularly in developing countries where these corporations make an enormous amount of money. I want to start, we all seem to be using different newspapers. I'm going to start by telling a brief story about the Niger Delta. I don't want to get into Nigeria, which is a mess in so many different ways, but I'm going to start with this article from last Friday's Post, then move on to discuss the country governance context, and then talk about strategies to force both multinational corporations and countries to move towards more public goals. Friday's Washington Post had this absolutely fascinating article that brings together lots of issues of corporate responsibility, civil society, the economy of developing countries, the short and long-term goals of economic stability, and most importantly for purposes of this conference, the need or lack of international law and domestic law. The article was titled Nigeria's Oil Morass, and it began on the front page of the business section. Now, this is the Post business section, so take this as it is. The lead was, quote, after insurgents attacked a link to a key oil export terminal on the Forcados River in Nigeria's Delta region in February 2006, it took a year and a half for Royal Dutch Shell to make repairs and get part of it running again. It took just 2 months for insurgents to shut it down again. This is in the context of America needing more oil and what a tragedy it is to have 500,000 barrels of oil per day being shut down by insurgents. That's one side of the story. There are two or three aspects to this story. We read about the awful insurgents. We read about the poor company, Royal Dutch Shell, the biggest foreign company in the strife-torn Niger River Delta, said it was going to take a $706 million charge against earnings, largely because of the situation in the Niger Delta. So we're feeling sorry for the company because of these awful insurgents. The article then continues. High oil prices nonetheless bolstered Shell's worldwide earnings. Profit was $8.7 billion in the fourth quarter. And Exxon's profit, which was announced that same day, was the largest ever for an American corporation. So, we start off feeling sorry for the oil company that has had these awful insurgents attacking. Okay. You then get to the continuation of the story on the last page of the business section, where you find out that the insurgents are a group called, and this is their acronym, MEND, Movement for the Emancipation of the Niger Delta, that has been engaging in these horrendous, and I do not mean to in any way approve of their tactics, these horrendous, inexcusable tactics. Their goal, however, is that MEND wants the companies and the Nigerian government to share more of the money that is being earned with the people who live in the Niger Delta. You also find out that even though the Nigerian government does give 13% of the oil revenues that it receives from these companies to the states, to the indigenous local states that produce the oil, the money gets waylaid. The former governor of the Delta State region has been charged with 128 counts of money laundering and related crimes, provided lots of money for the presidential campaign of the current Nigerian president, and Human Rights Watch has issued a series of reports. The most recent one mentioned in this article confirmed that little of the $1.3 billion actually allocated to reach the people in this area of Nigeria actually reached the people. So we can jump up and down. And I do jump up and down about transparency and corporate social responsibility, but unless the government's receiving the revenues and working with the companies are responsible, then we're pasting Band-Aids that won't stick very long on the problem and blaming the corporations for, again, I'm not trying to condone the corporations. I'm just pointing out this is part of a much larger problem. And indeed, the Human Rights Watch report that was mentioned in this article is one of many. Earlier reports had identified collusion between oil companies and the Nigerian government in denying rights to people who were living in the Delta state. The focus of the most recent report is on corruption at all levels of the government, with recommendations essentially focusing on the increased need for transparency, for information, as Larry was talking about, from all levels of the Nigerian government, and for donor agencies and foreign governments to press for this as well. And I tell this story just to remind us that to think about the countries, and I think I'm echoing John here as well, to think about the countries in which these corporations actually work. Now, the paper or the talk, my co-author and I develop a typology of different corporate governance contexts in which we propose 4 broad categories of countries, and we focus on sub-Saharan Africa because we know that best. And the typology looks at natural resources, commodity economic dependence, and good governance. So at one end of the spectrum are countries with economies and governments that are so poorly managed that there is little multinational investment, sometimes even in the context of lucrative investment opportunities. At the other end lie those countries with acceptable levels of good governance, more developed economies and markets, and comparatively high level of both domestic and multinational corporate investment. And there are different strategies. Our suggestion is that there are different strategies that are appropriate depending on the type of country that we're talking about. The first category of countries includes places like the Democratic Republic of the Congo, and is in the context of this topic, although lots of us have experience with it, sort of not all that well studied in the legal literature. And this category 0 country denotes the near absence of both effective governance and significant levels of foreign investment. So another country we put in this category, in addition to the DRC, is Burundi. They've long had weak, highly corrupt governments. They've typically suffered recently from war, and they are left today with relatively low levels of international investment. They have extremely ineffective basic institutions in the areas necessary to establish the prerequisites of corporate controls for any kind. They lack a reliable legal system, governmental transparency, and functioning legal markets, notwithstanding our best efforts to try to foster these things. And I think the thing that typifies for me, when I was living in the DRC, I lived about a mile away from the Supreme Court building, and in front of the Supreme Court building, every time I drove past it, there was a statue, and there still is a statue, of someone sitting there holding her heads in her hands and crying. And I thought, yes, this typifies the justice system there, where people stand outside and hold their heads and cry. I actually don't know why that particular statue was right in front of the Supreme Court. There had to be some other reason, but in the 2 years that I was living there, nobody could articulate why it was, except for extreme distress about the justice system. Global Witness has noted that about the DRC, instability coupled with widespread corruption is a major deterrent to foreign investment. Many mining companies, notwithstanding the existence of an exemplary mining code, are unwilling to take the risks involved in starting operations in countries which essentially lack functioning governments. And so, which helps set the stage for part of the argument in the paper, which is that we need to figure out ways to encourage MNCs to operate in these countries. The second category, category 1, denotes countries that are highly dependent on a single source of export revenue, often oil, and Nigeria is an example of this kind of a country. I'll come back to this in a minute, but Nigeria actually has very good laws on the books with respect to transparency and is, I believe, the only country to actually have enacted into law an extractive industries transparency initiative. Countries in this category try, but they are so dependent on a single oil source, on a single source of revenue, and the governance context is so corrupt that their efforts get them slightly farther than Category 0, but not much farther. And countries that are in both categories, in all of these, actually particularly in Category 0 and 1, are often victims of the paradox of plenty, the resource curse. These are countries that are highly dependent on natural resources, which World Bank study after study has shown, as well as other studies, that these naturally wealthy in resource countries tend to have slower growth rates than other countries. Resource dependence in these countries provides increased opportunities for corruption, and in these countries, oil and mineral exports, although not necessarily other exports, have an anti-democratic impact. So this resource curse can foster corruption, consequently can weaken government, and then can diminish accountability because government can use the money that they get from the MNCs that are operating there to cultivate patronage and also to cultivate large security forces. The third category of countries are not as poor as those in Category 0 and have a broader range of export commodities than the countries in Category 1. Kenya, at least until very recent events, Mozambique, Tanzania, and Uganda. The governments are quite interested, or at least they claim to be interested, in decreasing corruption and in improving the business environment. The final category includes the best run countries of sub-Saharan Africa, South Africa, for example, Ghana, Mali, and Senegal. In these countries, and you know, we can quibble about which countries should exactly be where, but our basic idea is that different countries in Africa must be dealt with differently because they are at different levels of resource dependence and country governance. In this top category, country governance is much improved. It's orders of magnitude better than in Category 0 countries. Economies are diversified and levels of foreign investment are already reasonably high. South Africa has the highest amount of manufacturing exports in sub-Saharan Africa and has an annual growth rate of 7 to 8%. Okay, so the central implication, about 5 minutes?
Yeah.
Okay. Central implication of this typology are that countries in different categories require different strategies relating to corporate responsibility. We certainly want to improve CSR in all of the countries, but the countries that the companies that are operating in Country 3 in the South Africas are very different from the few corporations that are operating in Country 0 countries. And so we actually think it is important to encourage investment in the country, in the Type 0 and the Type 1 countries. And just in college, I was one of those students who ran around with signs yelling, "My college divest," like all the rest, because the MNCs were the bad guys. And yet here I am, however many years, I won't reveal how many years later, arguing quite the opposite. But when corporations cannot rely on enforcement of contracts, when they can't rely on public bureaucracies, when they can't hire literate workers, then they're much less likely to invest in a country. And often in these countries, it is the corporations that are providing the education, that are helping with literacy, that are providing the good deeds, that are providing the healthcare clinics, that the governments are unable or unwilling to do. International economists are studying the relationship between good country governance and good business environments. Good governance results in improved development. And the World Bank did an exhaustive survey of the relationship between good governance and corruption using various concepts to measure good governance. And they found this correlation between good governance and per capita income. And, of course, they found that good governance in the country is critical to fostering sustainable development. They also asked corporate executives to list the most important constraints on their firm's growth in these countries. So when executives were asked to list the most important constraints on their firm's growth in these countries, they said corruption and ineffective government bureaucracies were second and third on their list, with only a lack of finance. Not a minor issue, mind you, but lack of finance as a larger constraint. So broadly, there are two sets of strategies that you can use to change these countries. The first are external strategies, which we've been talking about, and the second are internal strategies. They work together, so it's not as neat a dichotomy as I'm saying. Very often external, actually almost always, external actors in these countries can foster the work of the internal actors, and so the two types of strategies must be integrated. Let me just talk very briefly about in terms of talking about external strategies, there are four different kinds of external strategies. One of them is the voluntary codes of conduct. And those are, for a variety of reasons, voluntary codes are highly problematic. Although they enable companies to claim that they are doing good, and although they are better than nothing, there are problems relating to the quality of the codes, what they ask the signing corporations to obligate themselves to do, and whether or not all of the MNCs will actually sign. There are more than 77,000 companies that operate transnationally, with roughly 10 times that number of subsidiaries. Voluntary codes have to get a lot of people a lot of corporations to sign on. And even in the U.S., it appears that self-policing alone is insufficient. Mandatory programs, so mandatory base standards, support voluntary compliance, even in the U.S., which, is way off our typology of countries. In their study of EPA self-policing programs, Jody Short, whom some of you may have had as a professor, and Michael Toffel, found that companies are more likely to self-report when they fear being caught. So if they had recently been involved in outside inspection or compliance efforts, then that was a predictor of participating in a self-policing program. So voluntary programs only go so far. But that is an example of one of the possibilities for external types of pressure. Let's see. Internal pressure comes when actors in civil society take it upon themselves to improve what is going on in the country. And not to pick on the DRC, but to pick on the DRC because I've had so much experience there. One effort involved, recently, one anti-corruption effort involved a highly publicized trip of hundreds of miles up the Congo River on a ship with goods, just documenting all of the different places along the Congo River where the ship had to pay alleged duties or taxes, and just showing the level of corruption among petty officials operating along the river. I wish I could say it resulted in massive transformation, but no, it resulted in massive publicity. Donor governments and agencies were quite aware of this and are trying to do some more work on the problem. Okay, let me. So those are. Let me conclude by talking for just a minute about long-term strategies. There are certain things that can be done relatively quickly, such as this trip up the Congo River, which just documents what people are doing, where corruption exists, how hard it is for even corporations that want to act responsibly to do so. But there are longer-term strategies that will improve the governance of these societies, that will also then improve the environment in which MNCs operate, and then which will also pressure the MNCs. I mean, there needs to be this internal pressure as well that will pressure the MNCs to behave more responsibly. And these are things that are sort of outside of what we talk about when we talk about codes of conduct or international standards. But you've got to improve education. You've got to increase literacy rates. You have to develop an adequately paid and trained, appropriately sized civil service sector. So there are many, many things that need to go on outside of the corporations themselves. Socially responsible corporations can, as I said, contribute to these longer-term strategies. But if we're going to change the behavior of multinational corporations, disclosure, international standards are very important, but even more important is looking at what's going on internally in each of these countries and improving civil society. Paul Collier, some of you may have read his book, The Bottom Billion, former director of development research at the World Bank, has pointed out that revenues from natural resources provide larger revenue to the bottom billion of people in the world than does aid. So the countries are getting more money from corporate revenues than they're getting from international aid. But he points out these revenues are not being used very well. So, closing, let me just say the important thing here is to look at the country governance context. When we look at that, we can change the behavior of corporations. Thank you.
Well, thanks very much, and thanks to the organizers for inviting me along. I think as we've seen over the course of the day that one of law's functions is to constrain the powerful and to empower the weak. And I suppose as the representative of the NGO community here, and I hope no one asks the basis of my legitimacy in speaking on behalf of the NGO community, it's my duty to kind of to emphasize that dimension of law and perhaps international law in particular. As lawyers, of course, we seek to find the rights and duties that actually can help us to empower our clients and to constrain those whose interests undermine our clients' interests. When we're moving into the area of public international law, of course, as we've seen over the course of the day, it is particularly difficult, particularly challenging to find those rights and duties, whether they lie in custom, whether they lie in treaty law, whether they lie in hard law or soft law, whatever that may be. Even when we find hard law, we will find that hard law is difficult to enforce and to apply. So it's a particular challenge for us as international lawyers to find these rights and duties and to apply them in a way that actually advances our cause, our client's cause. There is a great deal of slipperiness around international law, whether it's hard, soft, or otherwise. And there's a particular degree of slipperiness around multinational enterprises as well. They have the means of moving between national jurisdictions, among international players, and with the guidance of slippery lawyers as well, they can navigate these constraints with relative ease. So for those of us who are seeking to constrain their power in order to advance our own clients' interests, we find this context particularly challenging as lawyers. What I wanted to look at is the development of an entirely new area of international law, the international law that's emerging to promote the fight against global warming, to constrain global greenhouse emissions, and the way in which this new area of public international law is seeking to engage multinational enterprises, corporations as allies in this effort, but also to constrain their activities and to impose standards on their behavior and their contributions to this growing challenge. So as we've seen in the course of this morning's discussions, we, as students, as lawyers, as practitioners, we demand responsibility of corporations. We demand this on behalf of shareholders, on behalf of stakeholders, national governments, whether they are the hosts of these corporations' activities or they are the home of the parents of these corporations, all seek to, in some way, demand responsibility or accountability of corporations. Intergovernmental organizations, whether it's the IFC through the development of the Equator Principles or the United Nations through its efforts to try to link corporations to human rights obligations, which is an effort that's currently underway and is just coming to light in full form over the past couple of weeks. These also seek to develop standards by which we can hold corporate actors to account. If we had been looking at this issue maybe 10 years ago, perhaps the focus of our discussion would have been precisely the opposite. How can corporations actually hold governments to account when they mistreat them, when they're operating within the kind of weak governance situations that were just described? And so there's a whole set of international instruments and domestic instruments that are basically aimed at just that, at empowering, in this circumstance, the weak, the multinational corporation, in the face of the strong, the national government, which is exercising through its legal systems, through its courts, through its enforcement agencies, an abuse of power over the legitimate expectations of that corporate entity. And so international investment agreements were basically put in place in combination with customary rules of international law to allow corporations to demand a level of protection when they were operating overseas, to demand a level of a minimum standard of treatment from their host governments to ensure that they were treated fairly, that their property wasn't expropriated without due process, that they were compensated should they be treated inequitably in relationship to their domestic counterparts. So international law is trying to emerge in certain circumstances when we demand responsibility of corporations. International law has helped corporations demand accountability of their host governments to a mixture of results that leads us to the situation that we find ourselves in today, where the rights and duties of corporations vis-a-vis the various interests that are affected by their behavior have to navigate this strange set of relationships that lawyers have created for us, and that are the tools essentially that we're trying to shape the world to come. Into this mix steps the growing international effort to regulate greenhouse gas emissions and to do something about climate change. And that's really what I wanted to turn my thoughts to today. Climate change has a way of turning everything on its head, of creating new sets of relationships, new rules, new laws, new sets of expectations. And the Kyoto Protocol, the 1997 Kyoto Protocol under the UN Framework Convention on Climate Change, was no exception in breaking new legal ground in trying to create a global response to this incredibly profound challenge. In the course of designing the Kyoto Protocol, and now in the course of some countries implementing the Kyoto Protocol, new relationships between governments, multinational enterprise, citizens, non-governmental organizations, and intergovernmental organizations have emerged. And this issue of what is the responsibility of corporations in helping to implement this regime, but also what is the responsibility of these new institutions that have been created towards corporations. These issues are now beginning to arise in a very concrete and relevant way. A little background on the Kyoto Protocol to explain a little bit what I mean about these new relationships that are being created between all these different actors. Those of you who have studied the Kyoto Protocol or have some exposure to it know that one of its great design principles, and from the United States perspective, one of its great design flaws, is that it caps the greenhouse gas emissions of certain countries, the wealthy industrialized countries, but leaves uncapped the emissions from developing countries. Now, this created a source of critique, a problem, a flaw in the regime, but also created a possibility of a deal emerging once those caps were set into place. And that deal was basically a means by which, a mechanism by which, wealthy countries, investors in wealthy countries, could find opportunities for inexpensive projects that would reduce greenhouse gas emissions in uncapped countries as a way of generating carbon offsets that those wealthy investors could then use to offset against their obligations domestically and internationally as operating within capped countries. This mechanism is known as the Clean Development Mechanism, and it was aimed at providing geographical flexibility and economic efficiency to those that were seeking the cheapest, most cost-effective opportunities for reducing greenhouse gas emissions. So essentially, it also offered an opportunity to tap into the entrepreneurial spirit of the private sector. If you could incentivize the private sector with the promise of carbon offsets, you could stimulate investments in climate-friendly technologies in the developing world. You could promote foreign direct investment and get developing countries on a path towards a cleaner energy future. So this is essentially what we call a project-based mechanism. It depends upon the ability for an investor to demonstrate that as a result of the incentive that's being created by the offer of this carbon offset, emissions are being reduced that would not otherwise have been reduced. So this requires any project sponsor to establish a baseline, a business-as-usual baseline of what would have happened in the absence of the investment, and then make the investment in a new technology, in a change of behavior, in, for example, the retooling of a power plant to make it more efficient, and then demonstrate over time that the emissions reductions generated by that investment are additional to what would otherwise have occurred. This requires, in order for it to function, a regulatory structure, an intergovernmental entity that would basically step in to guarantee in some way, to regulate essentially, to ensure that the baseline that is being proposed by the project sponsor is accurate, and that the emissions that the investor is claiming are truly additional to what would otherwise have occurred are genuine in nature. And so the Kyoto Protocol parties had to establish essentially a new regulatory structure, something called the Clean Development Mechanism Executive Board, to monitor the performance of the corporate sponsors of these projects to ensure that they were complying with the international regulations, the international standards that were established by the Kyoto Protocol parties. So there are examples, in contrast to some of the presentations that were made today, of intergovernmental entities that have been created that essentially do set standards and have the capacity to enforce those standards. How do they enforce those standards? Essentially by withholding project approval and denying the issuance of offsets that these corporations, these project sponsors, are requesting of that regulatory body in circumstances where those corporations essentially have not followed the rules. It was essential that we had this guardian, this intergovernmental structure to ensure compliance with these rules, because there is essential convergence and conflict of interest around the project sponsors, around the host governments, around the home governments in this particular deal. Everyone in this deal has an interest in demonstrating what essentially is a counterfactual, right? Every project sponsor wants to demonstrate that the emissions being reduced by this project would not have been reduced in the absence of an investment that actually is taking place. So we do need regulation. We need some transparency and accountability to ensure that the convergence of interests of the project sponsors, of the host governments that want the project to succeed so that they can get the profits generated by the sale of the offset, of the home governments that want to be able to use that offset to demonstrate their compliance with the Kyoto Protocol, that this confluence of interest doesn't lead to essentially the approval of offsets that shouldn't have been approved in the first place. So it's essential that we have in this circumstance a strong regulatory body that has the ability to enforce the regulations that the parties have established. Enforced against whom? Well, in many circumstances, enforced against a corporate actor that is involved in the kind of project investments that we've been hearing about today in developing countries. So the question that arises, well, what if a project sponsor is disappointed by a decision made by this intergovernmental organization, this executive board of the Clean Development Mechanism, and its project is rejected, its offsets are not approved for credit? Should they have a right to redress? Should they be able to take a claim against the executive board that their property right, their entitlement, their expectation around their investment has been denied as a result of the lack of due process, the failure of the executive board to properly interpret the rules that the Kyoto Protocol parties had created, corruption within the executive board? Certainly that isn't beyond the scope of possibility. Should they be able to have that right, should they be entitled to do that. So I'm flipping the question around that we've been looking at today, which is how do we hold corporations accountable through international law, to ask the question is there an opportunity for corporations to hold intergovernmental organizations accountable in certain circumstances where they feel that their rights have been denied through the abusive process. My concern as an environmental lawyer, of course, is that having helped to establish this guardian, this watchdog over this process, not to create rights of redress that could essentially undermine its effectiveness. We've seen many circumstances where the creation of international investment agreements, whether it's under the NAFTA circumstance or under bilateral investment treaties, in which when we have created a right of redress in a private actor, that right has been abused. And in some circumstances, private actors have essentially undermined the effectiveness of environmental legislation by claiming that legitimate regulations were, in fact, expropriations. That by not allowing a company to follow its original plan and introducing new environmental regulations, the government has essentially taken away a legitimate property right expectation, a profit-related expectation from that company. And international investment agreements, which provide a direct right of claim in private investors against their host governments, have in certain circumstances been abused and have undermined the legitimate authority of nation states. So do we want to recreate that dynamic here? On the other hand, my liberal tendencies, I share them as well, suggest, well, if there is this actor out there that is largely unaccountable to a private entity whose rights are directly affected by its decisions, shouldn't there be some potential for that company, even if it's an evil corporation, to seek redress against an otherwise potentially unaccountable intergovernmental actor? Well, this debate has become real, and it's become real because lawyers representing companies that have in fact been disappointed by decisions made by the executive board have begun to send letters to the executive board members as individuals and have said, well, we're disappointed by your decision, and we will take, if you do not change your decision, we will take such legal actions as we feel necessary in order to protect our clients' interests. No one really knows what that means. No one knows what right these private actors would be asserting before what court in order to advance or protect those rights. But it's a very important question for international lawyers to begin to explore, both from the perspective of the need to ensure that these intergovernmental agencies, like the executive board, can continue to perform their regulatory function without fear for illegitimate legal or vexatious lawsuits, but also to ensure that as we begin to create more and more supranational entities, that people whose rights or corporations whose rights are affected by the decisions of those agencies do have the opportunity to seek redress. The debate so far has been somewhat sidelined, unfortunately, by the fact that the immediate response of the executive board members was to be frightened, essentially, that they were going to end up traveling around the world in the course of their duties and find that one of these lawyers actually found a court that was willing to take up this case and maybe perhaps even entered a judgment in absentia against them, and they found themselves in the grip of a national legal system that acknowledged that some right existed and took some action against them. And so the debate basically became one about privileges and immunities. I'm not going to get into the details of what privileges and immunities are, but in short, there's a body of international law out there that protects international civil servants from suit within the national court systems of the parties of agreements that these servants serve, and prevents them from being interfered with in the conduct of their natural duties. But the issue of whether or not rights exist or should exist, and whether or not the international system should provide a means of redress for those rights, at the moment has not been dealt with by the parties. Instead, they move directly into this discussion of how do we protect our executive board members as they move internationally from lawsuits, whether they're legitimate or vexatious and groundless. And this has bothered me because if you look at past debates amongst those that were rehearsed this morning about the appropriate relationship between rights and duties of private actors and public actors, whether it's the context of whether or not the World Bank should be held accountable for human rights abuse, whether it's transnational corporations should be held accountable for human rights abuse, whether or not foreign companies should be able to hold host governments for account for the abuse of their rights, whether Small island states, should they be able to sue the United States for a breach of human rights? All of these are real live debates, and in each of those circumstances, the duty holders, the World Bank, the host government, the government of the United States, the transnational corporations, have resisted the characterization of themselves as duty bearers towards these assertors of rights, and have insisted that some legal theory must be developed to underpin why it was that this entity, the World Bank, is accountable for a human rights abuse vis-a-vis a citizen of another country. Why isn't it the intervening sovereign state? Why is it that one government, the United States, should owe a human rights duty to the citizen of another country, Tuvalu, half a globe away? Whereas in this context, for some reason, the issue hasn't sparked. The response of the Cata Protocol parties and of the executive board members was not to say, what right could you possibly assert against me? How do you see me as the executive board member as a duty holder vis-a-vis you, a corporate investor? Instead, it was to engage in the discussion of how do we develop appropriate protections against suits of whether they're vexatious or otherwise. This area of law, which is basically beginning to look at these increasingly complex relationships between new bodies and new entities that are being created by international law, by domestic law, is being characterized by the overarching framework of global administrative law. Taking the principles that we've developed at the domestic level that do help to explain why it is that a regulated entity, a power plant in this country, actually has a right vis-a-vis the EPA to challenge whether or not a decision by the EPA to deny a permit has been done in accordance with due process. These are the Administrative Procedure Act that you have all been studying as law students here. And there's an effort to try to project those principles of due process and legitimate expectations from the relationships that have been developed between citizens and their governments at the national level onto the international stage as we invest in the creation of more of these powerful actors at the supranational level. And it's those principles, I think, that I'm going to try to elaborate a bit in my paper to try to figure out, both in terms of my internal conflict of which do I think is the right outcome for this decision, but also trying to search for legal principles that could guide me towards some sensible outcome and to advise the parties on what that might be appropriate for them in moving forward with the climate regime.
Thank you all. And in a few minutes, we're going to open our discussion up for audience questions and all of that. I also have to apologize that in about 10 minutes, I have to leave because I have a class to teach. So if I walk out on anybody's comments, it's nothing personal. But I do want to give members of the panel who have been listening rather quietly and politely for the last hour or two a chance to either ask their own questions of others or any comments they want to make before we turn to the audience. John, do you want to anything strike you that you want to bring up?
Yeah, I really enjoyed listening to Larry's proposal, particularly the monitoring and evaluation aspect of it. And from my own experience, I remember as environmental law was becoming, well, it was a new thing in the early 90s being enacted in a lot of countries. And at the outset, a lot of the laws simply required projects to do an environmental impact statement or assessment at the outset, have it approved. Once it's approved, you get your environmental permit, you're good to go, that's it. It's on the shelf. Nobody ever looks at it again, as though we had perfect foresight and could predict every outcome of a project, as though we knew for sure exactly what the best available control technology was, exactly, what would be the impacts of various processes if we took certain measures. And I remember being stunned that nobody seemed to be interested at the outset in monitoring and evaluation and mid-course corrections. So this is one of the areas where domestic laws have now evolved based, I think, on evolving international standards, what constitutes international best practice. And it reminds me of an innovation in Peruvian environmental law for mining, which I thought was quite innovative, that brought together a lot of the things that we were talking about. They imposed something called a PAMA, which is an acronym for the Spanish phrase that means Program of Environmental Remediation, for existing mines that were being privatized, taken over by foreign investors or domestic investors for that matter. They had to adopt a PAMA, which was a program for improving, not totally, bringing something back to its virgin state, but remediating the environmental damage done by previous mining operations through their new investment in their new mining operations. And they had to have a plan that had to be approved by the regulator. And then they were subject to audits, environmental audits, every 6 months on a semi-annual basis. And the audits would be done by a new genre of environmental auditors. So this was a concept which actually developed a whole new line of business for the private sector in Peru, a whole new profession of environmental auditors who could only continue to work for a company for so many years, just like financial auditors in the United States, and who would be subject to their own independent professional standards and so on. So I think this is a really interesting area where a lot of innovation can take place, and which is really key. And so that really hit a nerve with me. I'm reluctant to comment on Dean Cahn's presentation because I could go on and on for hours and hours about the DRC. So I think we will have our little colloquium on that later. And I was particularly fascinated by some of Jacob Werksman's concepts about global administrative law, and I think that's a very interesting topic that I hope to see develop more in the future.
Larry?
Just really short, a couple questions. One of the things I was interested in, and I saw that in my study of Walmart and Gap, is that a lot of companies now are leveraging their relationships with the NGO community and hiring NGOs to mediate with NGOs on the construction of NGO-friendly responses. And I was wondering what your experience was with that in the natural resources area. But we can talk about that. With respect to the global administrative law, I'm wondering to what extent people are profiting from the 50-year or so, quote-unquote, constitutionalizing administrative law of the EU. Because there you've got a bunch of similar concerns, the creation of autonomous institutions that are at once constitutional and supranational, that are at once independent but derivative, and where the locus of sovereignty is kind of in tension, in the best way of putting it, whether or to what extent there's been some contribution. And for Dean Cahn, my question is, to what extent do issues or notions of development rights. In the North-South dialogue, for example, there's this notion that one of the responsibilities for inbound investment is development, not merely the kind of quid pro quo.
Not exploitation.
Right. And to what extent does that play in? So that's it.
So if you were asked a question in the last 5 minutes, you now have a few minutes to answer it.
Okay. With regard to global administrative law, this is really something that's being led out of NYU Law School. Professor Richard Stewart and Benedict Kingsbury at NYU have been writing on this and trying to build some momentum behind it. They are absolutely learning from the European experience. I think the big difference there, of course, is just the density of institutions and law within the European context, and the opposite of that in the global administrative law context, where you can have the creation of these top-down entities without any of the connective tissue between them having been established, as the example that I gave from the Cata protocol context. And that's really where you need to begin to backfill with principles and additional rules, where the process has kind of moved ahead of the theory. Can I ask a question?
Absolutely.
Okay. I had a question of Larry about this, just some clarification. Your proposal primarily, as I understand it, creates a legal obligation around disclosure. And then you said something about how then the national courts would be limited to enforcing that obligation around disclosure. And I wondered whether that would extend to limiting actions based on information that was disclosed as part of that disclosure. So are you actually saying that if a company discloses something in accordance with its obligations that reveals a breach of law, that you couldn't base a legal action on that revealed information?
Right. You couldn't base the action on that revealed on the basis of the international law requirement to disclose, but national courts would be free to apply national law with respect to that information in accordance with whatever national regimes they might have.
Okay.
It's interesting listening to the questions, listening to all of us as we grapple with how we can most responsibly promote development, which is, I think, one of the underlying questions. And I cannot think of a better metaphor. I mean, I wish I could. This is a really bad metaphor than the elephant, where we're all sort of taking different pieces of it, and depending on where you look at. I mean, I come across as saying, "Oh, rah multinational investment," whereas I very much in other places I've written about the importance of kind of leaving behind the law and looking at the rights of the people who are being affected, and as I said at the end of my presentation, literacy, good governance, things like that, which go way beyond what MNCs can do. Jacob was talking about how what rights might these corporations have? I mean, how do you think about the rights that they might have to challenge some of this? But the overall emphasis is on responsible environmental regulation. And actually, my question for Larry is, although I completely agree with this whole idea, I mean, I'm very much in favor of transparency, both from the government and from the MNCs, because without that, we don't know, we can't find out as civil society where to go after the money. Governments aren't accountable unless they reveal that. MNCs aren't accountable unless they agree with that. But it seems to me disclosure is an inherently political process, and information is not valued. I mean, you write somewhere in your paper, it appears neutral. Yeah, it doesn't. It doesn't appear neutral, and it's not neutral. And all of us who are pressuring for publish what you pay, for extractive industries to disclose, et cetera, information is not neutral. It's a nice way of trying to get at more responsibility, trying to get at more disclosure. But again, it's not. Countries will see it as probably infringing, and certainly the companies will see it as infringing.
Right, and the answer is, of course, you're absolutely right. And in a different piece, I've actually tried to unpack the notion of surveillance as a kind of. I'm sorry.
I was just going to say I missed John, so I won't comment on it. Sorry. Go ahead.
I'm sorry. Go ahead.
No. It was a question to you, Larry. It was definitely a question to you.
Right. I actually unpacked this, and the answer is yes, it's inherently political. But there are a number of approaches. One, yeah, you do want to use this for political purposes. But the other thing is you can make these innocuous enough so that maybe you don't need to worry so much about getting countries back up.
Thank you, Professor Langevoort.
I'll try to fill some pretty big shoes. If there's any more comments from the panelists or questions that you have for each other, please go ahead. Or otherwise, we can go and start asking questions from the audience if there are any. So, do you want to go ahead and finish? Or, are there any questions? Does anybody have a question that you'd like to ask any of the panelists here about specifically or in general their views on a specific topic? Please. There's a microphone up there if you could go, and that way we can hear the question.
So I have two questions. Well, the first one is it came up during Mr. Williams' discussion, but anyone can really answer it, is on the idea of development in foreign countries, such as example of Africa. I took the example of mining. You say that you work with these countries to develop their economy, somewhat of their, as long as they have somewhat of a stable, not so much corrupt government, to be able to work within their country for mining. But how there are criticisms that trade and development in these countries don't necessarily help the actual country itself, the people themselves. And the purpose of the question that were asked today was the public goals or for the public good. I don't really feel that you answered the question completely. So I guess I'm actually asking you to elaborate. Do you believe that going into these countries, doing the mining, attempting to develop for the purpose of for the bettering of your own economy and for your own growth of the industry, as opposed to for the country itself, or is it? So I guess is there public good? Is there public goals coming out of the reason why you go into these nations, into these countries, or is it simply for the good of the own industry?
Good question, a topic of considerable debate. But I think here the question is, can, should, and does international law influence business decisions? And the soft international law on international best practice tries to influence both industry investors who are going into countries in the first place in order to maximize profits, but also, and I think this was emphasized by Dan, there is a very great concern about reputation, especially among the larger multinationals. The evolving concepts of best international practice in mining does tend to make mining companies much more conscious of how they're going to be perceived and what's expected of them in terms of their contribution to sustainable development. At the same time, these practices have some influence on host country governments and administrations in terms of improving the law, in terms of the need to improve the law, the need to improve the ability to administer the law, the importance of being able to enforce the law. And I think one of the things that Dean Cahn talked about was the difficulty, even when you have a company paying substantial taxes and royalties to a national government, the difficulty of getting that money invested in developing the public goods. That is typically the function of the government and not the function of the corporation, to see to it that the corporation's responsibility is to pay its taxes, to abide by the rules, and so on. We have greatly expanded their responsibility to include a whole host of responsibilities towards the environment, local communities, and so on and so forth. Some of them provide the only health care available within hundreds of miles, the only education facilities available within hundreds of miles, and yet they are taking the place of government when they do that. When they pay their taxes, do those taxes then get put to good use, or do they get drained off? So what I was trying to emphasize is the importance of influencing not only the corporate culture, but also the government culture, and building the structures to make sure that the impact, the impact of investment decisions can be as positive as it can be on development.
Thank you.
Sure.
I have two questions. One is pretty fact-specific, probably for Dean Cahn. Has there, because of the nature of investigative reporting, we hear about companies that uphold dictatorships and support bad governance. Are there good examples in sub-Saharan Africa of corporations that have gone in and, rather than just say they were victims of bad governance, actually taken steps towards improving democracy, improving social and civic institutions? And then I'll ask the second question afterwards.
Why don't you go ahead and ask the second one?
All right. The second one is just more generally for everyone. This could apply to everything everyone talked about. Could one way of dealing with international law through hard law in the U.S., EU, potentially China, a number of other nations on forcing companies to respond to these public goals have laws modeled off of things like the Foreign Corrupt Practices Act, where you use domestic oversight in institutions to force corporate choice to uphold public norms.
Let me take the factual one first. Yeah, we do tend to hear of the excesses. 2 points in response to that. One is, as I mentioned, the sort of the voluntary good efforts, even in the U.S., come when there is hard law to support them. And so it is important to have international standards and laws supporting the good efforts of MNCs, because in the absence of either good laws or in the absence of pressure from the indigenous communities, which is very rare because they're very hard to organize, this doesn't happen. That being said, yeah, there are certainly individual corporations that run schools. When I was in Congo, Heineken, which was probably the largest MNC we saw, distributed condoms, supported not the U.S. government's ABC program, but at least supported trying to impact the fertility rate, which was 7 or 8 children per woman, and so dealing with sex education issues. So yeah, corporations do undertake that. There is, though, an important subtext that you've got to have. They do that when they're reinforced by the government, which is why the country governance context is so important, and then international standards, international outcries, public advocacy groups from within the country reinforcing these. But I guess a third point to make is that it's often in the long-term interests of these corporations to undertake these efforts. Short-term, yeah, they can grab what they want. Long-term, an unstable country, an illiterate workforce isn't going to help them achieve their profits. And so there can be an interesting confluence of both doing good, not just because it is morally good or even legally good, but also because it is economically good in the company's long-term self-interest.
Does anyone want to take the second question on, or?
Let me try. If I understand you correctly, the question is effectively to use domestic law extraterritorially to discipline corporate behaviors. If the model is the Foreign Corrupt Practices Act, it would be something like an American-based company's action under U.S. law for things that it does in Korea.
Right.
States have tended to do that, but you run into a lot of issues, most of them involving perceived infractions on the dignity of the states into which countries like the Americans are projecting their own law. Other states tend not to like it very much. And especially states that have just come out of long periods of colonialist or neo-colonialist kind of experiences, that kind of grates because no one invited them to Congress, for example, to figure out the mechanics or the substance of the Foreign Corrupt Practices Act. And yet, effectively, the Americans are trying to regulate behavior outside their borders. So that may be a little problematic.
Thank you.
I actually have a quick follow-up question for Professor Backer on that same topic. If you don't want to apply these national laws like the U.S. Foreign Corrupt Practices Act extraterritorially, under your regime where you have the mandatory disclosure and then the national courts act as the enforcement mechanisms, if the national courts of certain countries or if the legislatures have not enacted laws under which the national courts can enforce infractions of the disclosure regime, what do you do in that case to keep it viable and to actually achieve the goals to which you want to achieve if you can't apply the U.S. law or European laws extraterritorially in a nation where there are no laws in which the nation can enforce the rules?
Right. And that's actually right. And I consider that in the paper, and that's where I go from the sublime to the ridiculous and suggest that perhaps, given the limited nature of the remedial structure, that people might be able to stomach something approaching universal jurisdiction. Since you're looking at the same thing in every country and the same sort of remedy. But there I'm really going.
Okay.
I think the challenge for any actor that's trying to intervene into another country, whether it's the extraterritorial application of their law or it's the support of investment projects in the way the AFC does, or it's NGOs seeking partnerships with the local community, is to do it in such a way that strengthens local governance and local institutions and local civil society without replacing them and without undermining their legitimacy by suggesting that by creating a parallel public health system or a parallel education system or a parallel decision-making system, you are in fact delegitimizing the government and its function. And that's the challenge that all of these actors play. And it's in part a response to the first question. This whole effort is about, as Dean Cahn suggests, strengthening the capacity of national governance to govern wisely, including making the choice to allow foreign investors into their extractive industry sector. I mean, you can turn the moral question around as, would you deny them the right to develop by saying that you're not going to provide access of multinationals to their mining sector?
My question's to Dean Cahn, and it has to do with Category 0 and 1 countries that are heavily dependent upon extractive export industries. And so you obviously want to encourage multinational corporations to invest in them, but there's also the danger that those funds are going to be siphoned off to support the corrupt regime, or that you're not going to get the kind of sustainable development. And so do you think that international finance institutions like the World Bank can be a useful medium for sort of compromising between multinational corporations, or do you think they run into the same corruption problems that the multinational corporations run into themselves?
It's a very complex question. The people, Dan's not here to talk about this. The people at the bank, at the IFC, absolutely care about these issues, and they've started, the multilateral institutions have started to link social, I mean, it's actually probably the past couple of decades, but started to link social responsibility to their investment efforts. So far, they've not been as successful as the indigenous communities would hope, or as many other people would hope as well.
If I could take a stab at that one, and actually take a stab at the international financial institutions at the same time, it's very problematic if you want to, within a national framework, create a regime in which certain monies, tax monies and royalties, are being paid out to different levels of government. First of all, the national government might insist that everything goes into the national treasury before it gets distributed out. Well, the national treasury is like the Roach Motel. Things go in, nothing ever comes out. Even when I have run into the situation even where we have created, say, user fees and provisions for payments of taxes locally and getting credits that are offsets against taxes or royalties that are paid nationally to make sure that some of the money, a fair share of the money, goes to the local community and the local government and local projects, only to have the IMF come in and say, no, everything has to get paid to the national treasury, and everything is a tax, and you've just spent a year convincing industry that this isn't a tax, this is a user fee, and therefore your taxes aren't being increased, and this is a good thing. It's going to help make the administration of the sector much better, which is better for you, and everybody's on board, and then the IMF comes in and says, no, sorry, that's got to be paid to the national treasury, it's got to be accounted for as a tax, and we've got to see it in the accounts, and then it goes into the Roach Motel, never to be seen again. So it's a continuing struggle, particularly when local governments in some of these jurisdictions are so minimal. They don't even have banking accounts. They don't have bank infrastructure there to even deal with large quantities of money. That's a whole other set of issues. The amounts of money that can be generated by a major project such as a mine in a local community are totally disproportionate to the absorption capability of that community. Plus, they don't have any infrastructure for even handling the funds. So that sets up a whole another series of issues. But I think, little by little, we're drilling down to this level of practical problems that have to be solved in order to make development work. And that's why I kind of emphasize the local nature of foreign direct investment, particularly in the mining sector, and the fact that, yeah, the standards at the international level are important. Got to keep flexible because all kinds of interesting solutions are going to have to be worked out to make things work at the local level, and all kinds of practical problems have to be solved in order to put those investments to work in the things like education, healthcare, basic infrastructure, water and sewage, et cetera, that are needed for real development.
Yeah, we'll have time for one more quick question before we close up. Thanks.
Professor Becker raised the question that is it moral for countries, for big corporations to actually pay lower wage and health care in countries like India, Jordan, China. But it's actually, for a lot of countries, the people are receiving a lot more than they used to. And so it seems to me that there are different standards because to a lot of people, certain countries are actually in violation of human rights, but those countries have actually improved a lot of their human rights condition and is still improving. So on the other hand, we see international law, we think about a standard of like something that everybody will face equal responsibility or receive equal opportunities, as Professor Werksman was talking about the Kyoto Treaty, that why developed countries should actually take more responsibility than the developing countries. So how can we actually make international law that actually taking into account of different countries in different stages of developing and apply to some universal thing, but it's actually with different standards?
Good question. Yeah, no, it's an excellent question. And indeed, there was a report out of, every once in a while you'll see Business Week or The Economist run a corporate social responsibility expose. And in one of them, I think it was about 6 months ago, they talked about how, indeed, even though the multinationals are paying much lower wages than they would locally, they have an extraordinary impact on the wage labor markets locally because they pay more and they drive wages up even in the non-networked businesses. And they looked at China, for example. And I guess the answer has to be, the only way you can have flexibility is if you avoid, this is sort of my argument, and I'm not completely convinced, but I'll give it a shot anyway. The only way you can manage flexibility is to avoid substance, which is why my focus on reporting rather than on mandating a particular uniform set of responses. The ideal would then be, well, okay, we'll have the discussion we just had. Yeah, the Chinese garment workers are not earning American minimum wage, but now they're supporting their families, and maybe that's cool, and that comes out, and then you can make your investment and consumption decisions on that basis. But it comes out in the context of large, globally networked organizations fighting over the meaning and utility of that information for purposes of consumption and investment decisions.
Thank you.
Yeah.
Well, I think as in the climate regime, you see other areas of international law that take into account the concept of common but differentiated responsibilities, that have sliding scales, timeframes for taking on commitments, that give developing countries in particular a break when searching for an international standard. The problem is when you run up against things like human rights and international labor standards, in which it's very difficult to get the international community to compromise on those, to suggest that there are certain human rights standards that should be applied differently, that they're not sort of inherent to the dignity of the human being in order for the international community to stand behind them and to support them. So I think that's where sometimes there is a sort of a bottoming out of just how low you can go in terms of developing a minimum standard and how differential you can be, at least in principle, in allowing different countries to pursue different standards and to get the international community's blessing for that differentiation. On climate change, it's interesting because China has actually suggested that there should be an international standard on climate change. It's a per capita emission standard. So even in a context like climate, you can come up with an international standard that even the developing countries would support if you could gain some political will around that. Of course, the U.S. is quite resistant to the concept of a per capita standard in terms of greenhouse gas emissions. But
Thank you.
Okay. Well, thank you for all your questions. I'd like to thank the panelists for all their insightful presentations and also for answering all the questions. And again, I'd like to thank Paige and the Symposium Committee for putting together what I thought was a really interesting symposium. I hope you guys all found it to be the same way. So we have lunch, and this will bring to a close the 2008 Georgetown Journal of International Law Symposium. And please hang out, enjoy some food, and ask us any questions you want. Thank you. Thank you very much.
Yeah.
Kelly,
Thanks. It's actually, we organized.
Hi.